Good. Good evening. This is the May 18th, 2017 meeting of the Monroe Planning and Zoning Commission in Town Council Chambers. It is now 7:10 p.m. Please rise and join me in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Will the commission please introduce themselves, starting on my right?
Jonathan Formicella, alternate.
Kathy Lindstrom, alternate.
Leanne Ambrosi, Commissioner.
William Porter, Chairman.
Michael Riley, Commissioner.
Will Agresta, Planner.
Scott Schatzheim, Land Use Group Director and Town Engineer.
Rebecca Wood, recording secretary.
Okay, item number 3, a special organizational meeting for the election of commission officers. When Commissioner Hayden resigned, we lost the position of secretary, and we have not elected someone to fulfill that role, so I'd like to ask for nominations for secretary.
Mr. Commissioner, I have a nomination. I would like to nominate Michael O'Reilly for the position of secretary.
Any second?
Second.
Any others? All in favor of Michael Riley?
Aye.
Aye.
Unanimous. Thank you. Item number 4, general public participation. Is there anyone who would like to address the commission on an item that is not related to a current application or hearing? Seeing none, we'll move on to general appointments. Item number 5, N&J Construction LLC, 5 Independence Drive, to propose a text change to permit a contractor business with storage in the industrial zones.
Good evening, members of the Commission. Attorney Dominic Thomas, Cohen & Thomas, 315 Main Street, Derby, Connecticut, representing Nardi's Masonry. The reason that I have asked for this informal session to discuss possible zone change is really to address the seminal question, I guess, if this commission wants contractor businesses within the I-zone in Monroe. Currently, they are not permitted. I became involved in this case as a result of a notice of violation that was sent out with respect to Nardi's, and we've had some productive meetings with respect to how to address the issue with your staff. However, the bottom line is that a contractor business and a contractor storage yard is not permitted in the zone, number one. And number two, despite the fact that I guess in 2007, 6, somewhere around then, certain site plans were approved with these very large buildings, still limited with 20% outside storage. Those buildings and the business model of that size of a building and a contractor storage yard, whether it's the type of contractor that Nardi's Masonry is, whether it's a general building contractor, is really not reasonable, especially in today's, the way the businesses operate today. That's not to say that a business such as this can't have a building. Yes, it can. But the limitation of 20% outside storage, even with, I believe your regulations do exempt equipment, or vehicles, but even with that, they need to be able to have substantially more outside storage to be able to operate. So in looking around and looking at a prior regulation that was submitted to you and discussing with some other people who have come before you, it would seem that the I-2 zone, given its size, and I've traveled through it, looked at it, given the remoteness of a lot of the sites, would seem to be an appropriate zone for these type of businesses with appropriate conditions, with appropriate protections. These type of businesses do not necessarily need sewer and water, which is a limiting factor in development, and you do not, from what I understand, you do not have sewer and water in that area. There is really no need for a large office, and this impacts more than just construction businesses, it impacts other businesses. As more things become electronic, plans become electronic, and other issues, the need for office space shrinks. The need for inside work is still there, so in some cases, a small office is appropriate. In the case of the specific client of Nardi's Masonry, his business over the last 30 years has seen a change, and I can go back to when the idea of processing asphalt in one of my other clients was a rarity. 30 years ago, 35 years ago, you went out and you redid a parking lot, you went out and redid a road, you dug up the asphalt and you threw it in a dump, which nobody can, you don't do that anymore. You reprocess it, you reuse it for base or for whatever. That results in my client's, at my client's site, in the ability to take it in and create a pile of the asphalt being brought in, the old asphalt being brought in, and then it being processed, and then there's another pile that grows as that reprocessed asphalt is stored on site, and then it is taken off for jobs. So I guess the basic question, the first question that has to be asked is, do you want generically construction contractors and contractor storage yards in Monroe? In the I zone, I should say, because that's where they would be probably most suited. Second of all, if that's the case, then I think it behooves, obviously, the contractors, my client, to meet with the staff and come up with a regulation that is reasonable enough to allow them to operate their business. And that reasonableness would include a lot of things, not the least of which is appropriate buffering, landscaping. There's no reason why you can't have such a business that is appropriately designed, landscaped, appropriately protected from the outside, and still is able to conduct its business with its equipment on site, with its raw materials on site, whether that be process, whether that be soil, whether that be lumber, whatever the circumstance that they're keeping on site to use as they go from site to site to do their work. So that's basically the purpose of this, to see if we can proceed really to the next level, which is to be able to construct some sort of a regulation which would allow these businesses to operate within the confines of the regulations and provide appropriate protections to the town.
Okay, first, I just want to, I should have stated this before you even started speaking. I believe you understand that this is an informal discussion.
Absolutely.
Nothing, no comments, recommendations, discussions are binding on either party.
It's clearly spelled out in your application, yes.
I just wanted
Yeah.
that to be on the record. So
Absolutely.
that anything that is commented on by any of the commission members in this forum is not binding.
No, it is directional at best.
Okay. We have had some discussions over the last couple months about which direction the commission would like to go with construction yards in the I zone. You came to one of our subcommittee meetings.
I did.
So you're aware that we've had some discussions
Right,
on
and
that.
that's actually the second item on the agenda specifically, that, yeah.
I don't know if any of the other commissioners want to weigh in at this point with their opinions or comments. We currently have 4 or 5 lots in one of the I2 zones in town that have been granted variances by the ZBA for construction yard use.
Correct. And I think there are variances. What's interesting is you have a variance on this because of the change of addresses. It also, I would have to say, took me a while to find 5 Independence Drive, since it's apparently not a city street or not accepted, so it doesn't make it into your navigation system on your car. But yes, you do. It's interesting when I looked at it, and despite the fact that I am an attorney, despite the fact that I do litigate, it's not something I would want to litigate. You know what I mean? It's not the purpose of litigating it to say, well, wait, we have a variance for a contractor storage yard. Then the next statement would have to be, well, we can do whatever we want as a contractor storage yard. The question is, does that, the legal questions are, because you have variance, do you get around the
I believe you
20%
have a
outside
variance,
storage?
but you also have an approved
Site plan,
site plan.
Right.
So
special
you're
exception.
approved to do what is on that site. plan.
Right, exactly. And what, I guess the point is, building an 11,000 square foot building with what appears to be, and I'm not an engineer, maybe 2,000, 2,500 square feet of outside storage and a bunch of parking spaces doesn't fit the business model of a contractor storage yard in any way, shape, or form. So in the past, in some conversation, it was mentioned to me, well, many of these things operate by virtue of variances, which I've done quite a bit of land use. Proving a hardship might be a little difficult. I would think, and I don't think variances are the tool to be used for a lot of these things. I think the tool to be used is if it's recognized that, yes, we have this use. These are people who, at what point, I mean, these are business people, and I'm not just talking about my client. These are business people who pay taxes on their equipment, pay taxes on the land, spend money on other local businesses in town, hire other contractors in town. So they do have an economic input into the town. And they want to be able to operate a business, but in accordance with their business model. So in my opinion, the best way to achieve that is for a sit-down where a regulation is drafted that does two things, that recognizes how the business model operates. It's not something unique. You can go to other towns and look at other towns and see how they do it. But on the other hand, also addresses issues of buffering, issues of traffic if it's necessary. I mean, in traveling up Enterprise, Cambridge, Independence, and looking at the roads, you have a very good road system. I know it doesn't have sewer and water, so those are limiting issues as to development. But, you know, my point is to say if we can fit the use in here, because it is relatively isolated, it doesn't have, at least in the areas that I drove in, it had very little, if any, impact upon any residential areas. So there can be an accommodation where there is a regulation that's sufficiently protective and yet recognizes the business model. That's my main purpose. The fact is, yes, you are correct. There was a site plan approved in 2007, I believe, special exception site plan. And from that point on, there was business operations that were conducted that was not in accordance with that site plan. And eventually there were notices of violation. So we're trying to address that, because to address it, to say build the site plan is, I will state right now, is an impossibility. Build what's on the site plan.
Okay. As you know, your client has every right to apply for a zoning text amendment.
Absolutely.
What we are trying to get as our process is that a proposed zoning text amendment would come first to our zoning regulation subcommittee and be worked on there. We try to iron out any of our differences or come to an agreement on what we feel is the best amendment regulation. And then that gets presented to the full commission during a public hearing. That's how we would prefer to do it. You have every right to do it the other way if you prefer, which is just write your own text regulation amendment and submit it.
Yeah, and my intent, you know, as a result, so you understand, as a result of the notice of violation, we've had a couple of meetings with, well, first of all, with your zoning enforcement officer, then with the entire staff, and we met, and we showed to the staff a plan as to what we would do to address the issues that concern. Now, looking at that plan, we would need, obviously, to have a zone text change. That plan doesn't fit within your zone, your current zoning. I know from the next case, you know, the Delmedico's, Jim's Tree Service, where I did go to your subcommittee, and it was mentioned that you have this informal, and basically, that's why I came, is because the seminal issue is, would you entertain such a proposal? And I'm not saying a specific proposal, but a proposal to put contractor storage yards in the I zone. Right now, they're not considered in the I zone. They're not permitted in the I zone. And so then I would vision it as the next step. I received a regulation that I think was presented a year or so ago, which is a little more detailed than I would have done, but, you know, I've sat down with Kevin Soley and worked on it and prepared then, say, yes, there is not, as you made clear, and it makes clear in your regulations, there's no commitment on your part. But the point is, I guess, to say, if the commission is saying, listen, we are really not interested in having any contractors with substantial outside storage in the I zone, then that creates a different situation. If it is, yes, we will, but we need some you know what I mean? We need some protections. We are willing to consider it. Then the next step is to come to your subcommittee with a formula and try to go through that process.
Well, I'd like some comment and feedback from the other commissioners.
I would say, going to the subcommittee and looking at the proper precautions and things like that, I think that would be a productive way to continue this conversation about that.
Kathy?
Is it your understanding or that these businesses are permitted in other areas?
I do not think they're permitted. There's some reference, I think the contract, there's yards in the B zone.
Those are not construction yards.
Right, those are not, yeah, and so really, honestly, when you look at your regulations, there's really no location for the type of business that
That's
we're
correct.
talking about.
There's
Yeah.
nothing allowed right now in town for construction yards.
All right, so
Excuse me, except for the 4 or 5 lots
that
up in the
exists.
Pepper Street Industrial Park that have variances.
Right, okay. All right, so given that, I guess my comment would be that when that industrial park was created, it was created with the idea that it would be industrial, there'd be, you know, medical or warehouse, or there would be R&D or some assembly and manufacturing. It would not be for outdoor storage. And so, you know, the fact that those uses are not there, I'm not so sure that that negates the fact that they should be there, or we would want them to be there, or would prefer them to be there.
Well, I can respond to that in a couple of ways. Number one, I do my fair share of zoning in other communities around the area. Your area, as far as I know, and I could be corrected, you don't have water and sewer.
There's water.
Huh? It does have water? Okay, so you do have water, you don't have sewer. For some of the uses that you're talking about, especially R&D potentially, having public sewer is important, number one. Number two, I have spent quite a bit of time before the commission discussing issues of light industrial and the development of light industrial in related to some projects that I had pending before them. And there were marketing studies presented. And one of the points that was made is not to say that you will not have those kind of buildings built, but we gave a comparison that was thought by some of the commissioners to be very relevant when we were doing it. And we were talking about taking a piece of land that was zoned for, I think, their LIP zone, and it was a proposal now for a 250, eventually approved 228 luxury apartment complex. And one of the points that we made is that in Shelton, there is for those of you that remember Trim, that you cut your fingernails with, the Bassett Company, they were, they made the nail clippers. And they had a building, they were located in Derby originally, moved to Shelton, and they had a building on Trap Falls Road. That building on Trap Falls Road, they eventually sold out, and the building was empty. a developer that developed light industrial bought it right off of Bridgeport Avenue in the corporate area for $40 a square foot. Plowed, from what I was told, about $50 or $60 a square foot into the renovations and renovated it. And the comparison that this Realtor made for the commission was that that person spent somewhere between $90 and $110 a square foot, depending on the variations, to come up with this building, was able to rent, I think it's almost all rented now, to various light industrial places, as opposed to going in, buying a piece of property and constructing the building, which would range anywhere from $150 to $200 a square foot, including the land costs. So the point was that as industrial buildings shrink because of the fact of automation, because of the fact of technology, you're having more of them available, and they can be retooled for new businesses. So I don't think it's proper to say you will not get. I do think it's proper to say there's a substantial amount of land, and I think a regulation can address putting the contractor storage yard use in there without impacting what you want. But I think the idea that they would all fill up with those kind of buildings, I think, is relatively remote, number one, and the longer you wait, the longer the taxes don't come in.
Well, I would just, my only response to that would be the fact that we have seen new buildings going up in Monroe
Yeah,
without having public sewers.
Right.
So people who do want to come to Monroe somehow manage to make it work in a building as opposed to an open space.
right.
That's, that's all I,
Yeah, and that is true. That's why I said no one can stand up here and say you won't get the business. It's a question of what to do with the rest of the land.
Thank you. Leon?
Yeah, like, we've discussed it in the subcommittee meeting already, and we were going to look into it. Basically, we've already knew that there was a problem with some of it. We're in the process of looking into it.
Michael?
I'd like to ask the town planner, Will, do other towns have contractor storage yards typically in industrial parks? Or is there another designated area?
It's actually one of those uses that is far and few between. There may be places where towns have them on a very limited basis. I know one town that has it in one location only, and it's a place that
Is it
a
zoned
contract.
specifically?
Yeah, it was zoned specifically for that particular person, actually, which is not the way to do zoning. But there are others that have them. They would be more likely in an industrial area, but it depends on what you want your industrial area to be. There's industrial area and there's industrial parks. And there's a fine line to get those protections. Some of the protections are visual, some of the protections aren't as easy, like dust and noise. Those are harder things to mitigate when you're dealing with outside uses. Inside uses, you can mitigate those things more easily. So you have to think about, it isn't just visual. Yeah, you can make something look curved appeal and nice, and assuming the topography isn't such, you can hide things in a way that they look like everything else that's in the area. So it really, what is your vision for Monroe? What is your vision for the industrial district? That's something you have to think about.
How does it relate to the plan of conservation development, do you know? Is this addressed at all?
I'd have to look back at it. I don't know what it says about the industrial district.
Well, I'm thinking maybe a section of the industrial district could be designated for it. It seems like people do want this. There are others that have come before us asking for this.
It is in need of a use. A lot of these uses in towns are hidden in places that you don't know, and a lot of them, I hate to say, are in most towns historically just happened. And there are towns that are aggressively actually pushing them out, and that's what I hear all the time, that Bridgeport's pushing them out, and that's why you're seeing more interest as you go north.
There's some of the towns, there's two different issues when you're talking about them. It depends on the size of the contractor that you're talking about. I mean,
Right.
Nardi's is a larger contracting organization, it needs the larger piece. One of the problems with a lot of the towns is the smaller contractors who operate in their backyard. I mean, I was town council in Oxford for several years, and the complaints would come, Oxford would have these big, 4 or 5 acre lots, and sometimes they would remain hidden, in the back there. And there was one contractor who was a great stonemason. That's where he did all of his work, but then all of a sudden one day he got himself a new saw, whatever that you cut the stone with and everything. But not only that, but way on top of the mountain, a subdivision was approved. And somebody built a house, and they went out in their backyard one day, and they looked down, and there was this business. And so the effort there was to how to move them out, of the area. Some towns have adopted what they call industrial condos. But those are for the smaller businesses, not for the larger ones. The larger ones, they need really to be dressed in a regulation, like you said, potentially located, you can be in this area, and these are the requirements that you have within the zone.
I don't see any reason why, on the face of it, we would not want to talk about it further.
Okay.
I wouldn't rule it out now.
I think that's,
As I said, we have been kicking this around. A couple of things that I would be concerned about is the extent of outside storage, screening of the outside storage. You mentioned reclaiming or reprocessing asphalt. That is a little bit different in my mind than a contractor storage yard. That's more of a material manufacturing or producing facility. And, that comes along with its own set of issues over and above that of a contractor storage yard. So I would be very hesitant to say, yeah, we want to get a crushing operation and reclaim asphalt in our industrial park, because I don't think that would fly.
what's interesting about that is, I think your industrial park allows manufacturing, and I'm not sure whether it was a Monroe case.
Inside manufacturing.
And that's where you get into, but I'm trying to think of the mulch case. There was a mulch case. I'm not sure if it was the Monroe case where there was a determination that the making of mulch, which was done outside, by president, was manufacturing. And, that the trees were a raw material. But yes, these are all the issues that can be addressed. We understand it. The issues have to be
And
addressed.
funny, he's out of business.
Huh?
And funny, he's out of business.
What, the mulch?
So I think in answer to your initial question, yes, I think that the commission would consider further conversations concerning that use in the industrial zone. Said previously, we would prefer that any further action go through our subcommittee before it's actually presented as a text amendment application.
Absolutely. Thank you very much.
Thank you.
Appreciate it.
All right, next up, J&S Industries LLC, 17 Enterprise Drive, to propose a text change to permit landscaping, tree service business with storage in the industrial zone.
Attorney Nama Thomas, Cohen and Thomas, 315 Main Street, representing the applicant, J&S Tree Service. This one, in this matter, I actually drafted a regulation, presented it to the subcommittee, had a brief discussion with it. To give you a little background on it, I guess you could say this is similar but substantially different than what you just had, what you had a discussion on Nardi's Tree Service, Nardi's Masonry. The problem that my client has is that many years ago, he came before the commission and he received approval for a site plan to build a 30,000 square foot building, which he has constructed. The building has, I believe, 2 tenants. One is a moving company, and the other is his own business, Tree Service. There is an issue of outside storage. Before I became involved in the case, there were numerous things back and forth, requirements for as-built and everything. And basically, he needs a CO. And the reason he can't get a CO is because he has an illegal use on the property. And the illegal use on the property is his own business. Because this, whatever you want to call it, landscaping, tree service business, small contractor, whatever you want to refer to it as, is not permitted in the zone. So what I did is proposed a regulation that, and I will admit, from the beginning, I will say right up front, I drafted it directly to address my client's issue, because he has a 30,000 square foot building on the site. Not only does he have a 30,000 square foot building on the site, but if you go back and look at the history of his application, there is more land with which he wants to develop another building. But everything has ground to a halt until he gets his CO. So what I did is I drafted a regulation, which I presented to the subcommittee, which defined land maintenance, landscaping, tree service, and arborist. And then created a definition: any business related to the maintenance of land that includes land, shrub, flower, plant, tree planting, repair, maintenance, removal, including renting of containers. I will tell you that my client does have containers. These containers are used when he goes to a site to do trees, but he also rents them out. And in discussions with both Will and Scott, we discussed these issues. And I've gone back and forth with your staff on this. And then I created it in the I-2 district, gave it a use. We went back and forth on whether the use of storage containers would be accessory or a separate use. And then I developed some supplemental standards, which included that the business office of the applicant must be located on the premises. I maintained the 20% of gross floor, area is what I put in there.
For
Now,
external storage?
for outside storage. And I did this because, I was trying to be protective or trying to follow along the regulation as much as possible, because my client really needs to get his use approved within the zone so he can get a CO. Now, I do believe technically a CO can be issued while we're going through the process, but he would like to have the CO. And then at some point, once everything is cleared up, he would like to look into, depending on the market, the development of the additional land that he has. And there was, I believe, I don't know if it was, I don't think it was approved in the site plan. I think it was conceptual to have the second building put in. So we are talking about the buildings that you were discussing that you'd like to see there. So you have this very nice, very well landscaped. If you've driven by, I think it's 17 Enterprise Drive is the address. If you've ever driven by it, the front of it is landscaped beautiful. There are nice trees out in front. Easy to protect. I mean, there's really, the outside storage is really nothing to protect it from when you look at the next property, which is substantially upslope. And since I've been representing Mr. Del Medico, I've just seen some earth moving going on it, but I haven't seen any development on the property. And certainly from the road, the storage is behind the building. So I guess my, having been to the subcommittee with it and having the other informal on, I decided to put this informal on to see if I can get further impact. I think I'm ready either to go back to the subcommittee with this regulation, if that's what is preferred, that I proposed, or to certainly make an application and to have some discussion on, the issue of my client getting his use approved so he can get his CO.
Well, it seems that there's similarity in the uses between this client's business. It is a contractor of sorts.
Yes.
And you're looking to potentially make contractors' yards, construction yards. Why not tie it all together?
Because this, first of all, timing-wise, number one. Number two, my client can operate with the 20% rule without any problem. And he can, is agreeable to do that. He can operate within that. He has a 30,000 square foot building. Whether or not that is changed as it addressed, most of these that I've identified are what we would consider small, to a great extent. They're smaller contractors. They're the kind, actually, some of them are the kind you find in the backyards, with the tree truck or with the landscape trailer and stuff like that. So the point here, I mean, theoretically, with the amount of outside storage, if they went and became a tenant in a building where there wasn't a lot of outside storage, they have 20% outside storage, you would move them, generically, not talking about my client, you would move them out of it into the industrial area, into buildings where they could operate within the industrial area rather than in a residential area. Now, I don't think you have the regulation for it, but for a lot of these businesses, some of the towns have what they call industrial condo, or I call it industrial condo, where I have a client who built one. They're big Butler built, tall with a high bay garage, a small office inside, and then an outside area for outside storage. And you go in and they either are a condo where you buy or you rent your space, and it's geared to taking landscapers, tree service people, other people that don't have a ton of equipment off the road, or small contractors, home improvement contractors, off the residential area into this area. In this case, I'm being very frank with you, I'm addressing it to my client's situation because he's been frustrated for years trying to get his CO. And he's resolved a lot of the issues that were requested, the as-built. He had issues with wetlands, he took care of them. He's prepared to do whatever else is required, but I was able to draft it in such a way protecting the 20% because of the size of the building. And so that's why I did not go the route of including him in the general contractor, because I do think also these type of contractors are a different animal to some extent.
Yeah, they're permitted in the B2 and the I1.
Huh?
Those types of uses are permitted present in the B2 and the I1.
With the 20% outside storage requirement. But my client's building is, I mean, you would have the unusual situation of, when he built the building, everybody knew what he did, you know what I mean? But he built it, nobody was bothering, he was operating out of it. It wasn't until a few years later that all of a sudden said, well, wait a minute, you're not a permitted use. So, I mean, again, I don't see the issue. I don't see a substantial issue with it moving into the I2 zone, but that's why I'm here for the informal, and again, I've already shown at least a draft.
So it's not as intense a use as your first presentation?
Oh, no.
Anyone have any additional comments?
I feel the same way that it should go through the subcommittee and go through conversations.
Well, again, there wasn't much conversation, but I did go, to the subcommittee, but
We had a
you said
very brief
very brief conversation with it, but, if the same thing applies, again, it's to get the feeling that, this is actually less intense than the first one. I have no problem going back to the subcommittee and doing the process, because this is, in my opinion, a lot simpler
If you're
issue to
agreeable
address.
to taking that route, the best thing to do would be to submit whatever text you have in draft form to Will. He
Okay.
can distribute it to the subcommittee members, so at least we can review it
Yeah,
before the
absolutely,
meeting.
before you come to the meeting.
And speak a little more intelligently about it. And then,
Just, do you have a
we
subcommittee
don't
meeting
have one set.
set?
yet.
Okay.
We may have one scheduled one day next week. We haven't scheduled it yet.
Will has my email. If you could notify me when it's done, I'll get what I can in. Thank you very much. And I'll do a request
And you should just send me, and I'll let you know when it is. 'cause
Okay, fine. I'll do
they'll
that.
probably schedule one.
All right. Thank you very much. Appreciate
Thank you.
your time.
Okay, under general appointments, Laura Abbott. Is Laura Abbott here? Okay. Surprise.
How many
Was
times
she
is
supposed
that?
to come tonight?
She was, and we haven't heard from her, but the last time we talked to her, she asked for this date, so we'll do what we did last time, is that we will not put it back on unless she contacts us again.
Okay. This is about the fourth time that this one has been
Yeah.
on. Okay, moving on to public hearings. Since we have one new public hearing tonight, I will read the instructions for the conduct of the hearing. There are 2 sets of microphones for both public address and recording of the proceedings. Due to the need for recording, it is important to stand at the microphone at all times and speak into it loudly and clearly in order that everyone in the room can hear and to capture what is being said. Individuals speaking from the seats will not be heard and will not be recognized to speak. Rules and procedures of a hearing. Order of the hearing of an application. Points of order and responses will be entertained. Exhibits will be read for the record. Applicant and/or representatives will present the application and will answer commission questions. The floor will be open to those in favor. The floor will be open to those opposed. The floor will be opened to general comments or questions. The floor will be open to the applicant, who may take the opportunity for closing remarks or rebuttal, after which discussion will close. The applicant or his representatives are the final speakers. No comments shall be accepted from anyone unless recognized by the chair. All questions and comments shall be addressed to the chair, who will determine if an answer shall be provided and by whom. There shall be absolutely no discussion between speakers and audience. The Commission has no intention to limit the right of any person to speak, but asks that speakers try not to be repetitive. Please try to present new information. If something has been said before, the Commission would invite you to indicate your agreement with previous speakers. At no time shall there be displays of emotion such as applause, cheering, shouting, or similar noise. This is critical as this hearing is being recorded. If this happens, you will be cautioned. A vote or demonstration by a show of hands, standing by the audience, or similar action will not be recognized. All parties are requested not to talk between themselves while the hearing is in progress. If you feel the need to talk, please step out into the lobby. All speakers, when recognized, must advance to the microphone to speak. Please state your name and address for the record. The chairman reserves the right to cut off discussion if it is not relevant to the application or is presented in an inappropriate manner. This is a legal proceeding, much the same as what would occur in a courtroom setting. We request that all parties observe the proper decorum that would be observed in that setting. Please turn off all cell phones or similar devices. If you have a need to use these devices, please leave the room and use them outside. Okay, the first on our agenda and the second item on our agenda were for Web Circle. That has been postponed to our first meeting in June, which will be June 8th. Next up, item number 8. ZCA 2016-04, file number 1009D, 1615 Monroe Turnpike, Assessor Map 154, Lot 2. Petition application of Bruce Mondo, owner applicant, for a zone boundary change of approximately 3.46 acres from Residential Farming District 3, RF3, to Business District 2. And this is reconvened from 2/16/17. Mr. Rivas, thank you for your cooperation with granting us extensions on this.
My pleasure, Mr. Commissioner, and
We'll have to read,
Exhibit 26, certified mail receipts, notification, Department of Public Health, Aquarium. Exhibit 27, abutter certified mail receipts and green cards, public hearing. Exhibit 28, title search 1603 Monroe Turnpike. Exhibit 29, title search 615 Monroe Turnpike. Exhibit 30, letter granting time extension. Exhibit 31, updated commentary narrative by the applicant. Exhibit 32, updated town engineer comments. Exhibit 33, letter consenting time extension. Exhibit 34, updated town planner comments. Exhibit 35, letter granting time extension. Exhibit 36, public comment letter by David York. Exhibit 37, revised narrative with attachments from the applicant. Exhibit 38, updated town engineer comments. And Exhibit 39, letter from neighbors, the Wileys. That's all.
okay, for the applicant.
John Rivas, R-I-B as in boy, A-S, on behalf of the applicant Bruce Mondo. Good evening, Commissioner, Commission members, Mr. Chairman. As you probably recall, this is a reconvened hearing from February 16th, and I don't want to belabor anything that was presented at that point in time. It's already part of the record. However, the continuance was requested, granted at that time for several issues, the first being ownership of the road, driveway, right-of-way, however you want to classify it, that passes between 1603 and 1615 Monroe Turnpike, both of which are owned by the applicant, Bruce Mondo. Obviously, the only one subject to tonight's application is the 1615, which is presently an undeveloped, approximately 3.46 acre parcel of land. Regarding that open road issue, I want to start by saying that the prior submissions that I had filed, that are exhibits that were previously listed, namely letters and deeds, and I believe title searches that have now been filed and at least presented to Attorney Fraccassini. I do stand by the averments that were in that letter, in that my client can claim ownership of the road under the Connecticut statutes about owning to the middle on either side, and also based on the deeds that were submitted along with that letter and the property descriptions therein. We're by no means, waiving that claim in any way. However, at the last meeting, Mr. Chairman, you'd asked for some expounding on this based on Attorney Fraccassini's conclusion that the ownership of the road could potentially be in dispute. I had contacted the state as well, and I filed some documents, and I couldn't necessarily get a definitive answer on that, but they were willing to tell me that they don't maintain the road. The maps I submitted don't show it as a state highway. So I feel comfortable to further represent as part of that issue that Mr. Mondo does own the road, and that should not be an impediment to any rezoning of the lot in question. That being said, we've also submitted as one of those an amended map that shows the road pulled back. Commission is not satisfied with what we've presented. So, and I don't know if that's, is that on? That's
Yeah, it's on here.
It's not this one.
How do I go back to that list?
Either
I think it's
the folder, see the folder? No. Down the left,
down the
that one?
And so this is just illustrative of that notion. In theory, while it may present some other smaller issues, it needn't necessarily be part of the zone change for these purposes. So this is just demonstrative of the fact that could be accomplished. And a third point that I wanted to make about this is something that if the commission were so inclined, they could, upon their own petition, application, and the like, rezone the road to be B2 to kind of conform with, the fact that my client's 1603 parcel from which he's conducting his business is already a B2. Tracy Lewis, who's our surveyor on the project, is going to give a lot more insight as to sort of the site conditions, surrounding neighborhood conditions that would make such a zone change appropriate. Suffice it to say, if the commission, again, we're so inclined to button up this issue despite any ownership, questions. Is 8.3 of the statutes and interpretive case law all empower the commission to make that, that zone change on its own accord. So that being said, with those three caveats in place regarding the road, which was one of the main reasons this was continued, also to address some other issues that are no longer really on the table. The record reflects that we withdrew a text amendment that we had that was sort of part and parcel of a lot of the lengthy nature of our February 16th meeting. But Mr. Lewis is prepared to sort of describe the appropriateness of the lot for B2 purposes, the effect and problem, if any, with the utility easement that passes over it, as well as sort of the surrounding properties and their use that would, essentially this would majorly be an extension of an already approved B2 business, if you will, that's got, recorded site maps that go back a certain amount of time. Our intention and hope is that, and I think that map's in here, but Tracy Lewis will show it, is to potentially put a building, maybe a building that would provide under, I believe it's 423 of the regulations, some sort of storage warehouse by which, we could then aesthetically improve this present condition of the lot, and have a pretty much approved use with an exception permit then for the lot, which would then be maintainable as part of the 1603 business that's ongoing. So without belaboring that, I will turn it over to Tracy Lewis to sort of explain some of the site conditions. Thank you.
It's Tracy Lewis. I'm a licensed land surveyor and the owner of Lewis Associates here in Monroe, 260 Main Street, Monroe. To follow up on what John had said, we had the drawings that we submitted which show the surrounding area. This may take a minute to come up. On your maps in your file, it might be a little clearer, but I've highlighted the B2 zone. It's kind of crosshatched. You'll see that there's a lot of B2 zone around. As well, there's various similar uses in the B2 zone. We have the recently approved by this board, the convenience center and gas station here on the corner of Bridge Road. Bridge Road is kind of a residential road which leads down to the lake. This was the original road that went across to Oxford. This was the original bridge that crossed the river. There are some residential zones in here. Our site is, this red crosshatched area. This is Mr. Mondo's business area right here, where he has his office and his garage. Kind of bisecting this whole area is the railroad, which my understanding is not in use anymore. There's a couple of cave-ins on the railroad, and also down in Shelton, they have a hard time getting through down there because there's a building in the way, is what I heard. So this railroad is not in use right now. But there's also on this corner, there's like multi-use. There's a auto repair place, the tire center for Jensen's is there. We have the restaurant. There's been various restaurants in there, but historically the Howie Sad's restaurant, which was a very famous place that had hot dogs, hamburgers, and that kind of thing. But now I see that there's some vacancies in there, but they're pizza place and various stores have been in there. Also, there's the original residential home here up on that lot as well. We've also got down on this end, there's another liquor store, deli type thing that's been there for years, that's on this corner. This is the new shopping center that was approved maybe, I want to say 8-10 years ago, that has our new post office in there, and Dunkin' Donuts, and the tobacco place. There's quite a few businesses in there. On this side, on the other side, in the B2 zone as well, along the railroad used to be the old railroad station. There was a store here at one time, right here. This was kind of the mecca of Stevenson, if you could say, was between Howie Sad's restaurant and the store that was here and the railroad station, and the continual use of this road back and forth by Stevenson Lumber, loading railroad cars, and that this was pretty busy area, and the old post office was here too. On the corner is the Stevenson Firehouse. So in the back is the Wiley's property, which is residential, and across the street, across Route 34 on the corner of Bridge Road is a residential property. I actually worked on this property as well, and we had discussions about making this business at the time, this may turn into a residential situation on this side, but that is zoned residence. I did do a plan that showed the viability. I should point out Newtown as well. The town line goes through the center of Halfway River, and there's all residential on Newtown side. You have Old Stagecoach Road. To say what the road did, I can tell you from what I know, is that Old Stagecoach Road came, you know, like the hand is showing you, went down Old Webb Road, went down through here, hooked to what is now Cottage Street. The road came right through here and hooked to what is now Cottage Street, and that was Webb Road. And if you follow Cottage Street all the way to the top, it hooks to Webb Circle. That was the old original road. There was a portion here that was this little piece that Drings Road was put in, and I believe that that was probably built by the railroad company to access that one house. Since then, the road Route 34 has been reconfigured. It used to be to the south and had kind of a wild intersection here, circular intersection, if you might remember. So the state came through in the 60s and realigned these roads. So these roads have been updated to the point where they are very uncongested, I would say. So I did put together, and this is Stevenson Lumber, this parcel here. You require a 500-foot radius, but Stevenson Lumber goes, as you know, way up the street here. It's a large piece of property. So ultimately, this could be a B zone, or it could be something different. I don't know. I don't know of any plans, or Will does, but of what's going to go on that property. The railroad is extended and runs over the highway, as you know. It's probably, I would say, 30 or 40 feet above, maybe even more than the site. So I put together a conceptual plan that showed kind of what my idea of what it was. I also left some prints for you of that conceptual plan. Will asked me to make them a little bigger. They're gigantic now, so you can see them a little better, so I'll hand those in. So it's a little easier to see the site on this too as well, rather than those other plans that have all the lines on it. So this is the site. This is the Old Webb Road area going across here. This is Halfway River with the town line down the center. There's a small brook that comes through and extends across the former road. And there's some associated wetlands with that, which is very close and adjacent to
I can see
the brook.
it. Easier to share them.
And obviously the river has associated wetland lines too, and those are kind of, they're right on the edge of the brook. So we have the difficulty of the power line going through, and we showed the easement lines where the hand is. The easement line basically bisects the property, that one easement line, and then extends over to this line here. So, you know, at one point or another there may be more lines, but right now there's, I believe there's two or three sets of wires that go across. There is a high tension tower. You can see these contours that are going a little crazy here. That's because there's a high tension tower here that sits on that mound right now, and there's also a high-tension tower down in this area. They're on the map, but they may be hard to see, but there is some poles and stuff in here that this is all disturbed area. We showed a building here which fits in the 50-foot setback from the property lines. So we set a 3,000 square foot building in there. I put some parking in. I didn't necessarily look at the regulations for every ifs, ands, and buts about it, but I thought that an entrance through here and then probably an entrance out onto the Roosevelt Drive, Route 34. Obviously that could change. You could have an entrance coming directly in here. I think the tower's right in here, so that we'd have to be very careful with that. So I proposed this building here, which with the associated parking, I kind of trying to fit into the parking regulations. There would be some retainage along here. Mr. Mondo did some testing on the property years and years ago, and the material there is very good, so I don't envision septic systems being a problem. He had very good testing back then when he first bought the property. As far as under the railroad, staff asked me about the use of underneath the power lines. So I brought this deed is called out in Mr. Mondo's deed as an exception together with, so I'd like to present that. And basically the deed to the UI company or CLP company, the original deed allows him to use the land however he needs to. He needs to obviously run that by him, but he can't build a building under it. So that's why you see the building outside of the easement lines. So that building could be smaller with some more jigs and jogs in it, but I made it simple. I just made a rectangle. We're not here telling you that this is what we want to do necessarily, but without doing any engineering or anything else, I think it fits. I think it works. Its functionality fits in with the neighborhood in the B2 zone. A residential home at that site would just not be favorable. I don't see anybody buying a house on that spot with a high-tension power lines going across their deck. It's not a good situation. So that's how it would fit in. We have major highways on both sides, state highways servicing the site. So I don't ever envision that. And we're not going to ever build an enormous building. The site's not going to take it. It's going to be a 2,500 square foot, 3,000 square foot building. That's all that's going to ever happen. So this deed is volume 35, page 137. And I highlighted on page 138, and there's not a page number there. This 138 is the second page. I highlighted the items.
I'm going to pass it down by asking you, pass it back when you're done, so you put it in the file.
Let's see. I think that this drawing tells it pretty much. We would have to probably do some retaining walls in this area. It is very steep here, but it certainly works. Is that it, you guys? Any questions?
Well, is that the end of your presentation, or does Mr. Rivas have more?
Mr. Rivas probably has more, I would assume, yes.
Let him
But
continue-
if
let
there's
him
no
continue.
questions, I'm good.
I don't want to belabor, like, again, the record by regurgitating what I stated last time, regarding the history of the site, Mr. Mondo's use and presence there for a number of years, the fact that we came here in response to certain violations that were issued. I don't feel the need to inform the commission about that, so I really, I don't have much more other than to open up to the commission any questions that you may have of Mr. Lewis and myself, or issues now that we've, added to what was stated last time.
Okay. Jonathan, we'll start with you.
I don't have any questions.
I just want to be clear, so this, the new building, the proposed building, can you tell me what use, assuming that the zone is changed and it becomes a B2, so far, the way I see it, this area has turned into what I might call, I don't know if it's technically correct, but a village district. So there's convenience stores, there's a lot of things that make it convenient for people to access services. Are you envisioning that this would be another retail? I don't think that's what you said before.
I'm not sure, it's not envisioned in this conceptual plan that be the case, but I think that the site, and Mr. Lewis can probably inform more about the site-specific use, is capable, I think, of handling that, obviously with the certain restrictions and drawbacks of the power line issue and various setbacks needed for the wetlands areas. But
Right.
I think feasibly, the property, should we not follow through with the storage warehouse under 423, or whatever it may be, in the B2 zone to act as a companion to the adjacent property, then I think that it could hold some sort of light retail that would face outward towards Route 34 with ingress and egress along that road. That's not what's contemplated as part of this concept, but I think, and Tracy can back me up on this if I'm misspeaking or incorrect, but I think that is the case.
And
Kathy, this is a zone change application. They're showing one conceptual
Potential
plan
use.
for something that could be built, but anything that is a permitted use within a B2 zone could be built on the property if the zone were changed.
Then in that case, I don't have any other questions right now.
I have none.
Michael?
Well, I think we want to allow Mr. Monroe to conduct his business on his property. I'm just concerned with the violations.
No, please
Is
continue.
the building, or a potential building, meant to resolve the violations?
As best it can. I mean, that is part of a scheme that we have to, part of the issues, and this is obviously the theme of the night, so it might as well keep going, is outdoor storage. Different zone, same problem, same percentage that we're beholden to. I would say that the construction of the conceptual building will now obviously be able to be used itself. The parking spaces used, obviously, as parking spaces plus an additional 20%, and obviously we're going to have to conform after that. I mean, the space can only hold what it can hold. So, I mean, it's not, obviously the record is replete with the development and this way that this site has sort of changed over time by virtue of, materials being stored there, moved in, moved out, essentially by Mr. Mondo's use of it as part of his business across the street. So we're trying to alleviate that and at the same time, make it aesthetically pleasing, wherein there would be potentially, a retaining wall in a building that, work hand in hand with the, business across the way.
Okay, thank you.
Mr. Reeves, there are currently some zoning violations and citations on this property.
Yes.
What, if anything, other than filing this application, has been done to rectify some of those issues?
I don't recall the specificity of them right now. I don't know if Mr. Chairman, you have it in front of you. I don't.
Material stored off the property, over the property line, outside storage, an area that it doesn't belong. Has anything been done to try to clean some of that up? Is
Not,
there any intention to try to clean some of
oh,
that
yes,
up
I mean, this application.
prior to?
Well, yes, I mean, part of the reason that we came in and had meetings prior to any application submitted was in an attempt to head towards alleviating those. But I don't think any of it gets alleviated without this being in B2, one way or the other. Because, I mean, the residential zone isn't gonna be permitted for even the building that we want to construct. So, I mean, it's all a loss if it stays residential, and I think it's a loss for anyone going forward. I mean, Mr. Mondo, should he opt to sell this property to somebody and it's not rezoned, it's going to be, as Tracy said, I mean, you're talking about a house that needs to be built under power lines. It's not feasible or realistic for a buyer. I mean, there's a million other lots and properties that are much more appealing than living, under high-tension power lines that pretty much, as you can see, bisect the property almost down the middle. So, I mean, I think, but to the chairman's point, this is our attempt to resolve this, and we're going to resolve it in conjunction with the zone change. And anything that's above and beyond, we recognize that we're going to have to bring it into conformity, but we can't do it without the B2, one way or the other.
All right, I don't know if this question is for you or for Mr. Lewis. I still don't have a clear, solid understanding of who owns that right-of-way. It's not owned by the town of Monroe. We have not, our efforts have not been able to get an answer from the state. It used to be a state highway back in the 30s.
Can I interject?
Sure.
It was never a state highway. We have record that it's never been a state highway. It's not a state highway, and I can explain it to you. If we go back, I think the drawing we had was the best one, I guess, the conceptual drawing. Let's not click it on that. It's going to take a minute to explain the whole area, what I know, and from being around a while, I can kind of explain it. Originally, Route 34 was on the original state highway prior to the Stevenson Dam, was on the other side of the river. Okay, it came up. As a matter of fact, you can still see a portion of the road left if you go on the other side of the Stevenson Dam and head towards Derby. There's a big gate there, and then that's part of the old original road. That came up on the other side of the river, and that's how they got to the Bridge Road. Bridge Road came right across and came into the Stevenson area and into Monroe. Old Webb Road is named on the Newtown side as Old Stagecoach Road. So my perception is that Old Stagecoach Road was merely an access that followed Old Webb Road and once again went and connected up to Cottage Street before the railroad was here. And that was more than likely an ancient highway, ancient. I had stagecoaches. The abutment is still here where the original crossing was, and this bridge washed out. So Old Stagecoach Road remained because it had a couple of houses on it. Actually, the people that lived here were the Lovelands, which were heavily tied in with the UI and CL&P company. They worked for them and they rented here. If you remember Gene Loveland, our former historian here in town, was no longer alive. They lived on Old Stagecoach Road. And that was the road that came through. When the railroad came in, and Route 34 was constructed, Route 34 and the Stevenson Dam. The Stevenson Dam was done in around 1917, 1918. State highway numbers were started in 1922. There's no state highway numbers before 1922. And this road was built around the time of the Stevenson Dam, but basically constructed mostly in 1930. And that was the extension, the road, Route 30 basically ended here. There was no, these connections weren't made. This road wasn't here. And the state built that road and improved this intersection, which was a wild intersection. And like I said before, after 1930, that sat there for 30 years, and then in the 60s they came through and they realigned it like you see today. So that's my knowledge of the road. And the other thing is that it's not on your town record. So as a road that's owned in town, that's a requirement by the state. The first selectman has to keep a record of his roads. Most towns turn that over to their engineering department, keeps track of their roads, or whomever, they assign it. But the first selectman is in charge of keeping the names of his roads in the town. The state has a map for every town. They have a map of all the roads in that town. And that's how they keep track of it. That is not on there. What I think happened is that this road was abandoned, and it's in the town minutes in that book that's missing in the town clerk's office. There's one book that's missing in the town clerk's office for all the minutes of the town of Monroe. We were missing that book. And I'll bet you that that road was abandoned in that book. I can't say for sure, but that would be my guess, because it doesn't show up anywhere. So the town doesn't own it, the state doesn't own it. We have an indication from a title searcher, well-renowned title searcher, that says that since both sides of the roads were owned, the road was owned by Mr. Monroe, then he obtains the abandonment and he gets the road to the center. And that's the line I showed on the map.
Tracy, are you aware of the map that I provided to Mr. Rivas, which shows an alignment of a Route 145?
I haven't seen it, but I know I have a bunch in my folder.
And it's a state map, road map.
Could be a road map, yeah, that of a
It's a state
proposal.
map.
Yeah, it could be a proposal of something they proposed at that time. The alignment that you see there now is the final deal.
Well,
There was
the
never
long
a
and the
state, there
short
was
of it-
never a state road that went across.
We dispute that statement,
Okay.
because the information that Will has calls that out as Route 145. Short of having this missing book that documents the abandonment of the road.
I don't know if it, I'm not sure of that.
We have no proof that your client owns the property. And that's where we have a problem, because our regulations do not allow us to change a zone for anyone other than the property owner.
I understand.
So, well, let me rephrase that. Your client cannot apply for a zone change on a piece of property that he does not own. So that's where we have a little bit of a,
Well, we've given
Phenomenal.
you everything that we can. I mean, I don't know. I don't know. I'd be glad to look at what Will has. If he has it here, I'd be glad to look at it. But you know, we've checked and checked and checked, and it doesn't make sense that it was ever a state highway. It just doesn't make sense. It doesn't fit in with the historical uses of the roads in the area. It just doesn't fit.
And I could maybe further expound on it based on my conversations with people at the state regarding this issue. I mean, they've already represented that they didn't maintain it. The process of getting them to quit claim a right that they may or may not have based on, you know, what appears to be antiquated information is a unorthodox process in that they don't like to do it if they can avoid it. I've submitted other maps in our latest filings that kind of show the idea that that road wasn't called Route 145 on the state's own maps. So the notion that it showed up one time in one map in this one incident is creating an issue with all this other overwhelming evidence, I feel like, you know, if it's a balancing act, we're winning by a lot. And again, my initial part of this presentation, I had mentioned the idea that, A, we presented it, we're content for the road not to be zoned if this is such an issue. It's not, I don't think. I mean, my first position and my position all along has been, Steve Maggiola, who wrote that letter, is not some slouch in the industry. I didn't just find some favorable guy who I knew would write what I wanted to. He examined the documents, he examined the searches, and came to that conclusion. And it wasn't solely based on the statute that entitles adjacent property owners midway to the midway point of a road. It was also based on the descriptions of the deeds, which say that his property is bounded by this road. So it's twofold.
So that's just it, though. It said that the property was bound by the
Well,
road.
if I'm
By the
misquoting
road
it,
right.
maybe. I could read it specifically, but, and so the idea becomes, well, then, we don't necessarily need it, because, you know, if the lot is zoned, the lot is zoned, but I think it's in everyone's best interest to get that off the table. And thirdly, I mean, you know, the commission, and I guess in the interest potentially of resolving this to the benefit of everybody, you know, can zone that on their own petition, if so inclined.
The commission could if they were so inclined, but my point is, I don't believe that your applicant can.
I mean, based on what information, though? Did
Based
one
on the
reference
fact
and one
that
map?
We don't feel that we have clear, concise proof of who owns that road. That's the whole big issue. It's been the issue for the last month.
Okay, but explain,
The concern with that might be that we could approve it, get challenged, and we could be tied up, win, lose,
well,
in a long time. Whereas the other option is, if the commission can do it on their own, if they're of the mind to rezone this property, it is logical to rezone the road portion as well. And if that's the way to do it, to avoid a challenge that could upset the whole thing anyway, isn't that a better way to go?
I mean, if there's a guarantee being made that that's gonna be done, then sure. But, I mean, you know, I'm not, you know, that, to me, that was a new idea to me in the context of this application until about a week ago. So, I mean, you know, there's not an inordinate amount of time to react to it, but either way, the point is that I don't agree with the idea that that creates an issue whereby the commission wouldn't be on terra firma to rezone the road. Because there is an overwhelming amount of contrary evidence to that one map in question. I mean, it could be a misdesignation for all we know. I mean, that's what this is. If this truly is in the, you know, sort of, you know, procedure of a regular court hearing, the standard is a preponderance of the evidence. And it's overwhelming in favor of the fact that Mr. Mondo owns that road. You know, this is, and it's even, if you want to increase the standard, beyond a reasonable doubt. I don't see how, at a very practical level, that one minute identification in one map wins the day.
Reasonable doubt.
It's not. It's not. It's an unreasonable doubt because, I mean, there's nothing else pointing to that. There's not one other map, not one other document from one other professional involved in this case that shows that. So, I mean, that's, I mean, like I said, I've proposed 2 other alternatives to that, but while still disagreeing, because.
And your alternates are?
The alternatives were, well, one, that would the road not be part of the change?
I see, if the road were not part of the change, then in my mind, that's a clear issue.
No, it's anything. It's an alternative way of resolving an issue that we've been before and has been pending for a long time. To what? I mean, you know, to be able to finalize it, where I think that we have the wherewithal and horses to be able to do so. I mean, this is, I mean, the reaching out to get the opinion, to find all these things out, were done with the idea that this could be an issue. And we got everything that we could that points to it. And there's no one who said otherwise.
Believe me, Mr. Rivas, we've been doing a lot of homework on it ourselves, so it's not like, we're just sitting here, saying no. We've been doing a lot of.
My third point was that, with the road pulled back, there's the shaded in area. I mean, that could easily be part of it. It's still the property. The road needn't be part of it. The lot is zoned, and we can begin correcting the violation issues.
Let me ask Will a question. How does that affect the application if you were to pull that property line back?
Well, I mean, he's represented that it could go either way, so he's fine with you approving it either way. So there's nothing, it's been presented, it's here. You are gonna open it up to public comment, so it's been could be vetted, so there's nothing wrong with that. It's less, it's not more.
Right.
So if the commission were so inclined to consider a zone change for the piece of property excluding the road right of way, you would be agreeable to that?
Especially given the fact that if I'm not mistaken, that there seems to be some now talking about the commission rezoning the road on its own petition anyhow. I mean, we can then, because my understanding is that the rezoning of the parcel only is going to be, may create some access issues in that, we'd be accessing a B2 property over what's now zoned a residential road. But if it were in the works that was going to be remedied by the commission itself by putting everybody who needs to be on notice, it's a timing issue. I mean, if that had become part of this process, we wouldn't be having this conversation. And like I said, if you've got one B2 on one side and another B2 on the other, I mean, I would plead that the commission make that effort.
Well,
I mean, if not for alone, the logic of it. And again, that was sort of my third.
well, some would consider that to be sound zoning practices, but I'm not gonna comment on that at this point.
So those are my thoughts regarding it. I mean, like I said, time is of the essence, so to speak, for many reasons. One being that, we're running out the string on our own application, but B, the violations have been sitting for a long time, and we do want to correct them. We don't want them hovering over our head, contrary to the way this all may have seemed to go down. We do want to resolve them, and this is the only step that we see that even gets us anywhere close. Absent, relocating and selling the property. But it's not good to anyone as an RF3 anyway, so we may be doing a predecessor in interest, successor interest a favor, if that, as it may.
Any of the commission members have any other questions?
Just like one simple question, doesn't have a simple answer, but the question's simple. And if this is denied, what happens to that business?
If it's denied, what happens to the business?
Yep.
I mean, I couldn't say exactly how we're going to react if it's denied. I mean, we obviously have various appellate rights.
There are violations, there are there are situations that need to be addressed, and if we choose to not rezone this land?
Assuming that we don't appeal the decision and that the decision is based on the fact that you don't believe we own the road and I dispute that, and assuming all that doesn't happen and that we're in a state where it just remains RF3, I mean, to tell you specifically what I think we would do, I know you want me to say that we're just going to clear everything off the site and that's what it'll be, but we have discussed other things that we are probably protected by our privilege right now that I couldn't divulge to the commission without breaching confidentiality because it's not yet come to fruition. That's the truth.
So you feel the remedies would not be able to be addressed?
I can't specifically tell you all the potential options that we would have without first discussing it with Mr. Mondo and potentially breaching confidentiality because it relates to our strategy about an ongoing matter.
Anything else?
So-
Staff?
Oh, Leah,
What, Leon?
The zone change has nothing to do with your violations.
It does insofar as that without the zone change, we can't use this lot to remedy the violations.
Yeah, but the violation still exists on the property, so it has really nothing to do with the zone change. You haven't addressed the violations. I understand this may be your means to try to work that out, but it has nothing to do with the violations. The zone change has nothing to do with what's on this property right now.
It has to do with remedying the violations. I mean, if that's the shortest and in the answer that there is. The violations relate to some of it about outdoor storage and whether, contained in certain areas. Rezoning it and with the conceptual plan that we've set forth, we'd be able to remedy those issues. I mean, there's not a desire of my client, and again, I'm sort of backtracking to where we were on the 16th about his tenure at this property and his use of the property and things like that. It's not desirous for him, as a longtime resident, taxpayer and the like, to have to up and move. He'd rather use the property.
No, I understand all that. I'm saying that basically you didn't bring in an application with a zone change to address the violations.
I don't believe that
Well, I'm just saying is that's basically, it still has nothing to do with the violations.
Well, the part of the problem is that we're using our residential area for outdoor storage, which we can't do that in with an RF3,
Right.
but we can do it in a B2 with certain caveats, so it does address them. Maybe I'm
But there's
misunderstanding.
But there's violations on both properties, it's not just on one, so.
Well, yeah, no, this doesn't have anything to do with 1603. Oh, except for the extent that the new property, to the extent that the building is built and then has a 20% buffer for outdoor storage, can then contain some of the outdoor storage that's on 1603. So actually, in reality, it does, because in the
you're gonna
effort.
take the debris and clutter and
Right,
stuff,
yeah.
and pick it up and move it from this property to that property.
Well, not the debris and clutter,
Well,
it's
whatever-
business
whatever-
materials. I mean,
Whatever it is that is being, or we see as in violation, that's the plan, to use the new building, 20% storage area for
yes,
that
yes, in
stuff.
part, yes.
I just want to make sure I
Yes,
understand
yes, and so it's actually meant to be a remedial measure for both sets of violations insofar as that's the plan.
And the last question I have is about the road.
Yes.
With the state. You contacted the state, you said.
Yes, yes, I did.
And the state,
Was non-committal, but they did tell me this. They said, the multiple people that I spoke to, both from the Department of Transportation and I guess people in the Ways and Means Department, they essentially told me that they didn't own it, but they had to, they couldn't find any map that they had that referenced it as 145, Route 145. They didn't have any record of that. They had no record of maintaining it. So the only thing that they suggested to me as a way to resolve this problem was, what's going to make the town happy for us to quit claim you any and all interest we may or may not have? I said, well, what's the time frame on a process like that? And it's a lot longer than we have, let's put it that way. So is it an impossibility? No, but it's not something that they necessarily like to do, because it's a government, essentially agency, just making a blind representation based on facts that they don't even think are. I mean, they're essentially told me, yeah, we'll quit claim you the nothing that we own. And so, I mean, is it a belt and suspenders? Maybe, but that's the
I mean,
path.
but wouldn't your client want that anyway? The quick lane from the state?
I mean,
Because if
that's.
something came up down the road, years later down the road, wouldn't you want that?
I mean, only if we thought we absolutely needed it. I can't.
I don't own the property, but I mean, if I own that property, I sure would want the state to say to me that they put things over to me, so that going down the years, 10 years down the road, how you know if somebody doesn't come over and say, listen, we own this piece of property from the state, if you don't have that? I'm saying, if I was your client, I'd want that anyway.
Well, I mean, from a
But
more.
I'm just saying, I mean, I understand what you're saying about your time frame and everything like that, but I mean, basically, I mean, I think that, for us to make a decision on it, we're, like he said, we're gonna have to take the road out of it.
Well, let me,
Because you don't really know.
let's take a step back from the practical use of this road. I mean, whether it's owned by the state, whether it's owned by Bruce Mondo, the town of Monroe, or, anyone. The only access roads presently to both my client's properties, and the Wiley's residence is that road. So, I mean, as a practical matter, ownership or not ownership is not going to affect his ability to access his properties. I mean, there's a necessity that's created in the right-of-way he has over it. So own it, doesn't own it, he's coming and going, I mean, regardless, because there's no other way to get in. I mean, it's an easement by necessity at the very, very lowest form of it. So, I mean, at the highest form, we own it. Either way, he's got to be able to get in and get out.
But you do need it to be rezoned to use it to access the new property.
Okay. I mean, which is why, should it not be rezoned as part of this present application, then I would plead the commission to do it on their own accord, in the interest of good zoning practices. I mean, there's no, I mean, if there's really that much doubt about it, despite all the surrounding circumstances, then, I mean, I'm happy to proceed that way if the commission doesn't feel comfortable, making the determination of the road based on everything that's there. We don't agree, but I mean, and I think that's clear.
We understand that.
Yeah.
Any other questions from the commission?
Just a real quick one, and with all this conversation, I probably don't remember, and you probably did say it. Are these two lots combined?
No,
They are not.
they're not.
That's what I thought.
They're two separate addresses, 1603 on the left and 1615 on the right if you're facing from Route 111.
And so, since they are not combined, and let's say some mythical business goes into this mythical building that you're proposing, and that mythical person wants to use 20% of that building for outside storage, oops, what does that do for you? You don't need to answer that, I just raised that.
They could do that.
No, and then what does that do?
He owns the property, he controls that, Kathy.
I'm sorry?
They own the property, they control
The
it.
fact that the two lots that would not matter. That's my point.
They control the property, they decide what they,
Okay.
what they get, if they
It-
want
it
to use
doesn't-
it, or if they want
The
someone else to use it.
20%, doesn't matter what it is, they own the property. It's 20% of the gross
Of the
floor area. of the
whole
building.
amount, okay, so the fact that there are two parcels not combined
Doesn't matter.
doesn't matter. Okay, that's fine, just wanna know.
Anything for staff?
No.
Mr. Reeves, we want to open this up to the floor. Is there anyone who would like to speak in favor of this application? Okay, seeing none. Is there anyone who would like to speak in opposition to this application? Please come down, name and address for the record.
Carol Bradshaw, 328 Berkshire Road. Actually, Stagecoach Road tonight, I guess. It's Old Station House Road that I live on. My concern is, number one, the river and the approximation to the building being built. That parallels the river, just comes right down to the river. I also think that the remedy for the violations is like, I just see it as a bigger problem. If it has another building and another 20%, the problem becomes bigger, not smaller. Because I just think that he's in violation now and it doesn't matter. So if he makes another building and then he stores more, how is that gonna remedy it? Could just become bigger.
Well, I think the intention would be to store some of the material inside the building.
All right. That's all I have to say then. Thank you.
Is there anyone else who'd like to speak in opposition to this application?
David York, 14 Weekapigmy Trail, one of the little streets of Stevenson. Just a couple thoughts. One is, it seems to me for about 40 years, I've been going down whatever that road is, whatever number, name we want to give it. But I've been going down to see the Wileys and care for their dogs and so on. It seems to me that somewhere in common law, there's some, after so many years, I'm sure 40 meets that requirement, the property at least becomes available as a right-of-way, whether they own it, whether they have access, but there must be some kind of legal opening there. So for your concern, to me, it's not a question, and that is the only access that the Wileys have to their property that makes any sense. There's nothing else really viable for them to do that. The other simply is, where you've been talking about the violations, it seems to me a good stewardship on the part of the existing property that Monroe Company has. If they were to be carrying that forward, then this change might really make sense. But until those violations have been dealt with, it seems that, you know, what will happen with the new? Will the new violations, I mean, the new property be violated also? That's a concern. And then the other, as a volunteer fireman in the Stevenson Fire Company, please, there's one diagram that shows an access onto Route 34. I offer you to sit for 6 or 7 minutes at that intersection. When the trailer trucks come off 34, on 34, out of Newtown, and the road widens up and looks like it's a straightaway, we have some massive vehicles that are really going very fast, and it makes no sense to me to have further access onto 34. Onto 111, that might be a workable thing, but I think that access would be incredibly, I'm surprised we haven't had more accidents of more serious nature on 34 and 111 and Henny Penny and Dunkin' Donuts and so on and so on. It's a good busy corner. You know, the economy's doing well, but to add another dimension there be pretty hazardous, I think.
Thank you. Anyone else who'd like to speak in opposition?
Yes.
Which one can I pull out?
Pull out the orange one.
Only the orange one?
Or you know what, go on the other side of the computer, there's another point.
There's always little dongles over here.
Find it?
No.
Oh, those are it, okay. I didn't know we had two.
My name is William Wiley. I live at 1609 Monroe Turnpike. My wife and I both reside at that address, and I am a licensed PE in Connecticut. We would request that the commission deny any change to the zoning of 1615 Monroe Turnpike from RF3 to B2. There are a number of reasons for this. We'll start off by asking the commission to consider that such a change is not in keeping with the town's 2010 Plan of Conservation and Development. Another reason against the rezoning is that when a small piece is being rezoned with no benefit to the community as indicated by the inconsistency with the Plan of Conservation and Development, the rezoning is illegal spot zoning. In addition, of the 6 bulletin items in the Plan of Conservation and Development's Chapter 1.3, Monroe's future planning policies, his proposed change in zoning is in conflict with at least 3 of the policy, as it does not, 1, enhance Monroe's historic and rural character, 2, exercise stewardship over Monroe's natural features such as wetlands, streams, and Lake Zor. And 3, conserve land and natural resources. The commission should consider that such development will negatively impact the riparian and aquarian habitats along the Half River. This river contains populations of wild brown trout, which according to the Connecticut Department of Energy and Environmental Protection should be considered as a rare resource on a statewide scale. That's the way the river looks. Another reason is disregard. Go back here. Another reason is the applicant's disregard of the zoning rules. This continual illegal filling of the property as recently as Monday of this week shows its contempt for zoning restrictions. These were just taken just Monday. So he's knowing that he's got to come to an hearing, and he's moving earth around and filling in further and further. So any of the grades as shown on Mr. Lewis's map have all been changed already, just in a matter of days. There may be deed restrictions. Sorry. There may be deed restrictions about his accessing onto the state highway over here. So if he comes and puts a proposed driveway, that means the driveway comes out onto this, what used to be Route 145, which they seem to can't find anything about it, but I did find by my searches in the town. We would also want to point out that all the properties that would have a direct view of the property from the north and west are located in residential zones. The value of these residential parcels will most certainly be negatively impacted by its changes shown on this conceptual plan. One of the questions we have is, does this exclusion of Old Webb Road as well as his map showing a possible building and parking lot make this a new application and not just an amended one? A new app would require a new neighbor notification. Mr. York made some references to the access to this road here, this road here. We're not the only use of the right-of-way, that road. Eversource, which is the, come along after United but CLMP needs that road there to access their right-of-way. And I've been informed that they are going to be accessing that to get onto doing work on towers on our property in their easement. When we had moved in there, when I took occupancy, where my family has owned it since the 50s, the property, there was a stop sign located at the top of the driveway. And a number of times, even since Mr. Monroe was owned it and prior to his enlarging his entrance onto it, the stop sign had been knocked down and somebody came out and replaced the stop sign and put a new one back up. So we're getting this whole issue of who was going out there and putting a stop sign on a road that nobody, the state says, we don't own it and the town does. I don't know, I didn't see any name on the sign, whether it's the State Traffic Commission or anything like that. Is it also possible to say that we own the road because we are accessing our property, which is a residential zone, and that's our only frontage on a road? With his claiming the ownership of that road, we no longer have any capability of subdividing our parcel, which is a 22-acre parcel, which we are going to have to take a big hit if he excludes our use of that road. And that's one of the things, as well as negatively impacting, like I said before, these properties over here. We'll have to view his property here with a commercial building, which, well, he says, oh, okay, I'm gonna resolve that issue by taking the stuff off of here and put it over there. Well, it'll be the same issue all over again. Thank you.
Thank you, Mr. Wiley. Is there anyone else who would like to speak in opposition? Mr. Wiley, your thumb drive?
Yes.
Anyone else who would like to speak in opposition? Is there anyone with any general comments or questions concerning the application? Mr. Rebus, back to you.
Thank you, Mr. Chairman. Before it closes, I guess I would just say that I think that the comments before would have you deny this application based on Mr. Mondo's character, if you will. They don't like the fact that he's ignored the violations. They don't like the fact that he's done what he's wanted with his property that he owns. It's really irrelevant. I mean, at its core, it's nothing more than a red herring for the commission to look over here. He's a bad guy, whereas the reality is this is an attempt to bring the lot into compliance, so the very things of which you just saw pictures don't exist anymore. So the notion is counterintuitive. Everyone knows Mr. Mondo so well because they're such close friends with him that they can come here and say that it's not going to change. Obviously, that's not the case. And finally, I think, that Mr. Wiley's intentions, shine through. He wants to develop his property in the back for a subdivision. He doesn't want Mr. Mondo further driving away potential suitors or buyers of that property. It's got nothing to do with why we're here. We've got a taxpayer who not only owns this property, he owns the property across the right-of-way, which is 1603. He owns his home, which is also in Monroe. He wants to continue to be able to stay here and use that property for his already existing business purpose. This isn't in response to any questions about the Halfway River, any plan for that property will involve proper accounting for the wetlands and rivers and things like that. I mean, if I haven't been clear before, I'd like to be clear now. This is a remedial measure. This is not going to be an extension of an already existing problem. And the only reason that the problem is existing as it is now is because Mr. Mondo was permitted to disturbed for decades. So it's unringing the bell as a process. And we're in that process, and we're hoping to complete it properly. Thank you.
Thank you, Mr. Rebus. What's the commission feel about this? Close the hearing or keep it open?
Are we satisfied that there is no place else to get definitive information about the road?
I think we've kind of played that one as far as we can, haven't we?
I've gone as far as I can. I think Mr. Rebus has done as all he could.
Jack Fracasini's been working on it. We've gotten all the information we're going to
We're
get.
gonna get, okay.
Open and close.
Close.
Okay. Hearing's closed. Okay, next up, item number 9. This is a new public hearing. I'll ask our newly elected secretary to read the public notice. Read that.
In accordance with CGS 8-7B, a public hearing will be held in Town Hall Council Chambers, 7 Fan Hill Road, Monroe, Connecticut, on Thursday, May 18, 2017, at 7 p.m. or soon thereafter, concerning the following. SEP Special Exemption Permit 2017-04, file number 15878, 230 Roosevelt Drive. Special exemption permit change of use for veterinarian clinic. Dr. Rakesh Val, applicant, Sergio Fernandez, property owner. Complete details and copies of all relevant materials associated with the above matter are on file and available for viewing in the Monroe Planning and Zoning Department offices. you want to read the,
You're gonna rely on our, all right, let me get it for you.
You have to attempt to lower this one.
There you go.
I gotta read these exhibits, please. Are these different than what you've already submitted?
We submitted for the aquarium and health department. Those are for the butters.
Yeah, I have the exhibits.
Those are just the hard copies.
Yeah, these are more original, those are just having. Exhibit 1, special exception permit application. Exhibit number 2, property survey map. Exhibit 3, town engineer comments. Exhibit 4, fire marshal comments. Exhibit 5, health department comments. Exhibit 6, town planner comments. Exhibit 7, building official comments. Exhibit 8, certified mail receipt green card application for acquiring water company. Exhibit 9, response to comments. Exhibit 10, resubmission of CP application. Exhibit 11, 2-page plan set. Exhibit 12, certified to receive green cards, Commissioner of Public Health. Exhibit 13, town engineer comments. Exhibit 14, updated town planner comments. Exhibit 15, response to comments by applicant. Exhibit 16, SVP application materials. Exhibit 17, plan set materials. Exhibit 18, updated town engineer comments. And Exhibit 19, a butter list, certified mail receipts and green cards. That was all.
For the applicant.
Good evening, Commission. My name is Harry Rochel with Atlantic Consulting, representing Dr. Valley. He's proposing to change the use of the existing vacant retail space at 230 Roosevelt Drive to a veterinary clinic. This application is similar to a previous but not implemented approval, SCP 2014-09. The property is located in the B2 business zone. It's approximately 1.4 acres with the shopping center being about 9,200 square feet. This veterinary clinic would be an outpatient practice for dogs and cats. The facility would provide a wide range of wellness and preventative care services, as well as emergency medical conditions. Most of the services would be by appointment only. There would be no exterior site work for this project, besides adding a do not enter sign, which was part of the approval from the previously mentioned SCP 2014-09. And that will be at the Westerly Drive at the entrance of the site. Zoom in a little bit, you can see it right here. The space that the tenant would be occupying would be between Subway and the cigar shop. It's about 1,500 square feet. Proposed clinic will conform with the special exception permit standards set forth in section 8.2.2 of the zoning regulations. As part of the conversion to a veterinary clinic from a retail space, will be measures taken for the containment of medical waste for disposal, soundproofing for the adjacent tenants, ventilation to remove odors, measures taken for the handling of deceased animals, and also a location for animals to relieve themselves. That'll mostly be in the back area or in the front grass areas, as is common practice. And all those measures are stated here on the architectural sheet under notes. You can zoom into the new floor plan here. This is the existing space, basically just an open space with a restroom in the rear. Restroom will stay in the rear, and there will be partition walls put up for different exam rooms, waiting room up front with reception, consulting room, exam room, package prep in the back would be mostly surgery with cages for animals, operating tables, and the likes. Medical waste containers are shown right here. The freezer for deceased animals will be right here. They will be only there for approximately 24 hours unless cremation is going to occur, and then I believe it says it will be picked up within 2 to 3 days typically. Right here on the drawings, there's a schematic for the soundproofing. This will be further specified bearing approval at the construction document phase of the project, and will be further worked on at that point. As I said, there's no exterior work to the site. The The zoning regulations for parking are the same as it was for the retail space. The site is currently private well and septic system. The health department had no concerns with utilizing this as the water is kept to a minimum use at the veterinary clinic. Not much more to say about it, as there's no really exterior work. It's just basically changing it from retail to veterinary clinic.
Okay. Now let's just see if anyone, let's start with Michael. Any questions?
So do you have area for the animals to relieve themselves?
Yes, so I'll bring that up. So that is stated right here. It has grass around the front in the parking area and also around the back. I believe it's next to the drive-through for the Dunkin' Donuts in the back right corner of the parcel if you were looking at the front of the parcel.
These are common areas?
I could say, yeah, you could say they're common areas. In what's that?
Public areas?
They're on the property. I don't think they're used for anything. They're basically just grass buffers that are behind the parking spots. And in the front of the area, it's a grass berm between Roosevelt Drive and the parking area.
And that's usual and customary?
Yeah, for veterinary clinics and strip shopping complexes, it is that's pretty standard procedure.
Okay. That was my only question. Thank you.
Leon?
I'm good.
Kathy?
Just to follow up on what Mike asked, all right, so we all know what happens when dogs, mess on grass. Grass doesn't like it very much. Who's gonna be responsible for, number one, cleaning up, and number two, keeping the grass green? I mean, are we gonna be looking at a bunch of dead grass?
Second time here, so we had the same issues last time also. So basically, our staff is going to be responsible for that. Now, having said that, the grass area, most of the time, this is a veterinary clinic, not a veterinary hospital. So our number of people coming to this clinic is much less and lower than a normal veterinary hospital would have. Yes, there will be some dogs and there will be some defecation and stuff outside, but we'll try to keep it to a minimum, and whatever our staff is going to be there, they will be responsible for cleaning.
Daily?
Every day, yes, this is part of it. It's like a health thing issues, and we would like to keep our facilities very clean. So that has to be daily, if not even maybe 2 or 3 times a day.
And is there an area to walk the animals, if they've been in the
There
park?
is, on the side of the Dunkin' Donut, there's some areas provided by the landlord, and he's okay with it. And there is a good amount of area, yes.
Okay, and, so one of the concerns, I was here the last time around.
Yes, I remember that.
And so one of the concerns that was, discussed was, we understand animals die. They will be in a freezer, they will be kept in, minimal amount of time until such time as they are either picked up by the owners
Right,
or taken to a crematorium.
that's correct.
Do you have a generator on site in the event that there's power failures?
We don't have it, but we can install it. That should not be a problem, depending on, I don't think anybody in that facility, all the 5 retails have generators, unless the landlord has it, I do not know. And as you said, and I'm going to say that again, the chances of that happening is very, very rare. And most of the time, if a client's animal will die, they will pick it up and they will make their own arrangements.
I'm sure it's rare, but,
Yeah.
I'm looking at.
That's what the owners, it is
Sometimes
owners.
we could be without electricity.
I
in the
do
wintertime
understand.
or
I
in the
totally
summertime
understand
for-
that. In
for
that
days.
case, the owners are going to be responsible. We can clearly tell the owners that, hey, this is your responsibility. We are having a problem with the electric issues. They'll take care of it. They should.
The last time around, we actually asked the health department to look into those few
They
issues.
did, and they didn't have question this time.
So does that mean they addressed those issues, or does that mean
They
they
spoke
didn't
to us,
bother?
they spoke to us, I spoke to them, and they had no further questions or no further issues.
So you were able to assure them
Yes,
that these issues that we discussed a couple of years, 3 years ago?
That's
or so,
correct.
Have been addressed by you, and they were agreeable? to
that's
that?
correct.
Okay, thank you.
I just have a couple
Sure.
questions. On your diagram of how your office is going to be set up, you have cages near the surgery prep.
Right.
Is that just to hold the dogs while they,
Yes, they
while
come
they
in,
wait?
yes,
before-
exactly. They come in the morning, so if there's a dog with vomit, diarrhea, you have to just give them injections and stuff. We hold them for a few hours till, we do the treatment and they go back.
Right, and that's not to hold them for boarding purposes?
Definitely not, because one other thing is, we have a bigger and a larger hospital in Newtown, so if there is any cases like that, we can transfer there, or there are multiple overnight facilities, emergency hospitals that we can refer them, we mostly refer them there. So that we don't have to worry about, nobody's going to be there in the building at night, so we don't want the dog sitting there at night without supervision, especially sick animals.
All right, thank you.
You're
So
welcome.
you will have a nurse, if you have a dog there overnight,
We will-
recuperating from something or other, somebody will be there?
No, we do not like it. We will not have a staff at night, so basically they will be transferred to a bigger hospital, which will have facilities 24 hours.
And how about noise abatement? I did see here.
We'll put some baffles up there, but this is a very small facility, very small, closed, so I don't think there will be any problem with the noise.
All right, hold on one second, I just want to find where it says, okay, so,
Can you highlight that, the baffles one?
so the fire marshal said, they wanted detailed plans of construction and also on the baffles and sound control panels.
Yes,
Have you provided those yet?
yes.
We
Well, that'll be
provided,
part of the building permit process.
Yeah, that will
Right.
be the second phase.
we provided a schematic, and we would, further specify it following approval with the
Okay.
construction drawings.
That's it?
Dr. Valley, it seems like you've covered all the questions that we had last time around.
Yes.
I just, for the record, we received your letter, no boarding, no grooming
Right.
will take place. Maybe some incidental bathing as part of your
Yes.
veterinary services for an animal, but you're not going to be grooming dogs.
Definitely not.
Deceased animals, there's a conflict here that I just would like you to explain.
Sure.
You're going to have temporary cold storage, and they may be stored temporarily for up to 7 days. Then in the next paragraph, you state, all dead animals must be disposed of within 24 hours after death.
Yes,
And then in the next paragraph, you say, dead animals will be in cold storage for no more than 2 to 3 days.
yes,
So
I
we
think.
have three conflicting
Yes,
statements.
that's true, and I noticed that this time somehow there was a glitch or something. But realistically speaking, the ideal way to do it is when there's a death, something like that, the owners would be responsible. We will have them take the dog or the cat, whatever is there, and it is going to be their responsibility. If at all there is, sometimes there's grounds are frozen, people request that, hey, at 7 o'clock at night or 5 o'clock, I'm not going to dig a hole right now. For their convenience, we can tell them, okay, we'll hold it till tomorrow, and then the cremation services, people will come in and pick it up. They're on call basis, you can just practically call them, they come in next day, if not the same day.
Okay, so you
Yeah, we can
strike
delete.
these
Yes, we can do that.
comments from
Yes.
your plan. Okay, I have no other questions. Staff have anything?
I don't.
Scott? All right, anyone from the public here to speak in favor or in opposition to this application? Any general questions or comments? All right. It's back to you.
Well, we would request the change of permit, thank you very much.
Thank you.
Thank you.
Close, close. Hearing's closed. Thank you.
Thank you.
Quick 5-minute recess?
Okay, 5-minute break.
I didn't say it.
28, we are back in session. Next up, item number 10, SCP 2016-11, file 1581A, 269 Purdy Hill Road, Assessor Map 21, Lot 18. Special exception permit application for 16 detached age-restricted single-family residential dwellings on a common lot with associated private internal roadway and appurtenances for property consisting of approximately 10.2 acres with an age-restricted Residence District 8RR, owner applicant Beaverbrook LLC. Kenneth Twombly reconvened from 4/20. Will, anything new?
Yeah, we have two additional exhibits. Exhibit number 40, cover letter from the applicant with a two-page plan set. Exhibit 41, updated town engineer plan.
For the applicant.
Thank you, Mr. Chairman, members of the commission. My name's Dave Bjorklund. I'm president of the firm of Spath Bjorklund Associates. We have offices here in Monroe, and I'm a professional engineer registered in the state of Connecticut. As Mr. Porter said, this is a continuation of the hearing that was held on 4/20, and there were a couple of items that were left open at that meeting, and I'll go through those right now. The most significant one was the existing home on the property that's at 269 Purdy Hill Road, which is located right here. There was a question as to whether the driveway could be classified as a pre-existing non-conforming structure. The attorneys for my clients and the town attorney went back and forth on this. We held a meeting with staff and the attorneys on Tuesday, and there was not a resolution that was apparent under the pre-existing non-conforming status of the property. So what we have done is we have added a note to the plan that we are going to I'll read the note. The existing three-bedroom dwelling to be retained as a construction office until 80% of the units, that's 12 units, receive certificates of occupancy. At that time, the house and the driveway will be removed. The area will be graded, loamed and seeded. The septic tank will be abandoned as required by the health code. We have also forwarded a copy of this plan to Scott so that this can be reviewed. Just let the Inland Wetlands Commission know that there has been a change in the site plan. The house itself is out of the regulated area, but we felt that it was prudent to just let the Wetlands Commission know what was happening on the site.
Mr. Bjorklund, that note is not on our drawings, or are there any other changes to our drawing other than that note?
No, on this sheet, that's the only change.
Okay. Thank you.
Is that note.
When the house is demolished, there's no replacement at all, nothing?
No, and we're not replacing it with another unit within the development itself. The other question that was left open at the last hearing was with regards to the lighting. We had a discussion that the street light at the entry, which is a single pole mounted structure, the light was spilling over across the property line, not in conformance with your lighting regulations. We had thought it was a good idea for safety, but as Will pointed out to me, it doesn't conform to the regulations. So what we did was we simply took that lighting fixture and slid it back. We made the island a little bit longer so that now we are in compliance at the property line. The other issue that had been discussed at the meeting was we submitted an overall lighting plan with photometric levels on it that is part of the file. And we attained compliance with the Commission's regulations by using a commercial structure, a commercial lighting unit, which we would prefer not to do. We have searched high and low for a simple residential lighting fixture that is compliant with dark sky. And we have not been able to find one. I've looked at every source I can. I even spoke to a lighting engineer this afternoon that we've done several larger projects with, and she indicated to me that, Dave, at this point in time, it doesn't exist. So we're hoping that, and what we'd like to have the commission condition the approval is that keep the lighting plan that we have submitted that does comply to your regulations, and hopefully by the time we're putting in our first lighting fixture in front of the dwelling, that we will be able to find, or somebody we'll start to manufacture a fixture that is compliant with dark sky. Or we'll go to the local welding shop and have somebody make something with a shield on it that will be dark sky compliant. And I believe that those were the issues that were left open at the meeting on 4/20. If there's any other questions, we'd be glad to address them.
Jonathan,
I don't have any further questions.
Kathy?
No, I don't think I do, depending whatever somebody else says, I don't think so.
I have no further questions.
Well, I don't like the idea of, being part of the commission that requiring you to destroy a perfectly good house. There was no other way around that. I mean, that just doesn't make sense to me.
I think we all, I'll speak for Scott and Will, I think we all put our best effort into finding a solution. The only way that the regulation would have to be changed.
And that would take
A text
months
amendment,
to do.
yes.
No.
You know, I have some similar feelings that Michael just expressed, but on the same token, properties, buildings get demolished for new construction all the time. So if that's the decision that your client has made, I can understand that it's part of the process. I did have a note concerning the lighting. I was not aware that there was no residential fixture that complied with dark sky, but would you be agreeable to a condition of approval that the lighting fixtures be reviewed by staff prior to
Yes,
installation?
yeah, that's what we would hope would happen, is that when we
Okay.
find something, we'll come back in and share it.
And my only other comment is concerning the plant list. We have changed our regulations. We don't go by caliber. We go by, what is it, diameter breast height?
Yep.
So your plantings, the size of your plantings should conform to our current regulations.
Okay, if we could address that in a condition, and when we submit the final plans for recording, we'll modify that.
I also, I understand that Mr. Twombly is going to be the person in charge of the landscaping design and layout. And that's good. He has a good reputation. We know he's gonna do a good job. If Mr. Twombly gets run over by a backhoe on a job site next week, I would like there to be something in the approval that gives us a little more input into the landscaping design, because right now it's pretty vague. And it's pretty much open to Mr. Twombly pretty much laying it out as he goes. We do have this typical residential planting, but, there were some areas on the site, like specifically the corner of Purdy Hall and Cutler's Farm, where the existing vegetation and make it look good. We can't put on the plan, we're gonna make this look good, and have something that we can construct to. So I'm not opposed to leaving it a little bit open, but I would like also that there's something in the approval that gives the town a little more substance and teeth in the issue if for some reason this project is sold or something else is being done when it comes time to landscape it. Is that agreeable?
Yeah, I'm just trying to figure out how we would state as such.
Will?
I think we have to fashion it to be that there'd be a little bit more oversight with staff during the time of that installation, and that, if it becomes for lack of a better word, an impasse or something with that activity, that it can go back up to the commission for resolving whatever issues there might be. So that if it does turn into an opportunity with someone else who isn't committed to the plan the way Mr. Twombly is, that might come right back to them anyway, so. But by then, you're out of the picture, so that shouldn't be a problem.
Yeah, I would just that. What,
I'm Ken Twombly, owner of the property. Everybody's assuming I'm gonna get killed before the property's done. You know, Will's mentioned it 2 or 3 times, now you mentioned it. And I'm sort of
I'm hoping you don't.
But, you know, on the landscape plan, everything is basically laid out as to what we're going to plant. I don't know where the problem comes in, other than the corner.
Well, the corner is one specific example, but you also said that you're going to pretty much
And I'm going
lay it
to-
out as you go.
Yeah, well, I'm gonna lay it out, but the plants that I've laid out on the plan are what we're gonna use. Now, if it says we have 7 Japanese cedars, you know, and they're all ranging from 12 to 16 feet high, which is way beyond you know, what the town wants, and I only need 3 of them to accomplish what I need, I'm not gonna put 7 or 8 of them in just because it's on that plan. I mean, it just doesn't make any sense. You know, I'm gonna go according to what it looks like and how it lays out, and that's all I can tell you, you know?
And again, that's, that's not how the process works.
But let me say.
Let me finish. I mean, you know, the commission approves a plan, the details are there. The people who are going to do the inspections to check against the plans aren't here, aren't involved. So they rely on the paper, they rely on the plan. They don't rely on the fact that they can move that stuff around. Because if you don't do it, you're not gonna die, you decide you wanna sell it. Someone else has to do it. What plan are they following?
They would follow the plan that I have right now that probably would be way over planted.
There are places on your plan that you've represented you're going to plant that aren't on that plan. You talked about putting trees around the center area. They're not on the plan.
They're on the plan, the last plan that I did. I put in sweet gums, I put in quite a few plants around that area.
I would say that they're not, but that's.
You know, I put in some, there's quite a few. I don't have the plan in front of me here, but I redid that section and did it.
For me, anyway.
I think this is an individual house.
Can I make a suggestion? Is it possible to have what I would call, you know, a minimal plan that Mr. Twombly and the town would agree to, understanding that you might add enhancements?
Well, it's all I want to say, you know, is this basically is my last project that I'm doing. We got actually I'd say about 90% of the plants that you see on this plan right here are sitting on site right now. So no matter who buys it, if I sold it, they're not going to throw them plants away. They're going to follow this plan right here and put them in. The only thing that I would say that would be happening is you probably would be overplanting, especially on Verde Hill Road.
I don't have that plan with me, but what are you proposing in those clusters of 3, 3, and the single?
These are evergreens right here to buffer that house, so when people come in, they're not looking right at that house. There's deciduous trees right there. This is a buffer here between the houses. And believe me, before I get done, I would have a plant like right in here somewhere. I would do plants over in this area somewhere. This is a big tree out here. Actually, it's an 8-inch caliper linden that I'm putting in. we're putting in big specimen plants right in here, so when I drive in here, as we develop this, I don't wanna see that house right there.
What are those evergreens?
These right here are spruces.
And my point that I'm trying to make is that everyone here believes that and has confidence you're gonna do a great job.
Yeah.
But that's not the point. The point, if you aren't doing it, for whatever reason, the things you just said aren't on that plan, and there's no way the town can tell anyone to do that.
No, but these trees right here are on there and say that will be enough.
I don't,
You know?
well, I don't think they are enough, but the things you wanna do is.
No, but what I'm saying is, well, as these plants right here are on there, they're oriental spruces, so they're gonna stay on there. So if I don't do the project, that's what you're gonna get right there.
I get it, but there's not a single plant anywhere near the mailboxes. And I know you're gonna make that look nicer when you do the landscaping around the mailboxes.
Yeah.
And I can't make anybody do that with that plan other than the comments. And I don't know why you're really worried, because if you're not doing it, it's not your problem anymore. So as long as you're doing it, you're not gonna have a problem to do what you want.
Right,
So whatever condition we're putting on isn't gonna hinder you.
yeah,
It's only in case someone else does.
right. Yeah. So what is it you would,
Excuse me, hi, I'm Kim Dianziger, I'm one of the other principals in the project, and I understand the concern, of the commission, and I think I have a solution that hopefully will take care of the situation. Appreciate that you recognize, that Ken is going to do a good job, and that we're a small community, and that we're going to do that. Have absolutely no problem, stipulating in as part of the approval that should Ken not be part of this project at the end, that whoever takes over must submit, another developed, another landscape plan. So the approval specifically for us, if it's sold, another, so no one can buy the project without, bringing in another landscape plan. And just make that a stipulation of the approval.
What do you think, Walt?
Yeah.
That'll work.
All right, that's great.
That's great.
That's a
Solves the
good
problem.
That'll work.
Thank you.
Good, not a problem, solves the situation. I only had one other comment, and that is the lighting on your sign at the entrance. Has to be a down light, can't be enough light.
In the new set of plans, that light's been eliminated. The floodlight shining up,
Right.
that's been eliminated.
no light?
No light on the sign at all? Well, okay, but when you come in with your sign, if you want it to be illuminated, it has to be a
If
down
we
light.
decide that the actual sign is still up in the air, so we'll get back to you on what that is actually. But the floodlight shooting up has been removed.
Okay, I have no other questions.
No way to work around this house deal.
They're proposing what they're proposing, and if that's what they're happy with.
Okay, but I mean, because like Mike had concerns, I did have concerns too about ripping it down. And well, there's
Again, obviously, we would like to keep the house, and we pursued it from, on the basis of, of trying it through the legal system as a pre-existing, home. One of the alternatives was to remove that home and replace it with another home. Ken and I both felt that, the project is optimally designed. We don't want any greater density. That's the whole idea, is to make this project look good, not just, for the sake of making money. Don't want to lose money, but, the idea is not to shove another house in just, to recover that cost. We would like to see if we can explore other issues, but we don't want to hold up this, this hearing. I mean, if we understand we're big boys. We understand that, what we've asked for here. However, we'd appreciate if we can come up with something else to, that where we can, bring it back to life. We'd like to approach it, but not as far as this application. We don't want to hold up this application any further at this time. So.
Just two little questions. Do you know the age of the house when it was built?
1957.
1957, so it just barely fits into the, I mean, it probably
It's
has no-
literally, it was, the zoning came in within less than 12 months, of the construction of the
So it
home.
has
So
no
that
major significance historically, that's.
there is absolutely nothing significant. The only thing that, in terms of where we are on the home, is that, it would, it's obviously paying taxes right now, which it wouldn't be, obviously when it comes down, and it's a less expensive home than, the other homes. So it would be a nice opportunity for somebody to have an age-restricted home within the project that isn't going to be as pricey. They won't have the amenity of living on, on the new road, but they would have a home that, they're getting their lawn maintained, their driveways shoveled and everything for a significantly lower price. And it's kind of shame to take that out of the housing inventory in town. It's an interesting opportunity for somebody, but recognizing that we couldn't get the town council to see our view on it, and his interpretation is that there is no way under the existing statute that we
Town council
can do
means
it.
the town attorney.
Town attorney, and so we couldn't do that. However, obviously, we have, there are other avenues. There's zoning, Board of Appeal, and also a revision to the regulation itself. So, hopefully we can work with staff and with you, to come up with something that's, that's suitable to everybody. Because yes, it is a shame to lose it doesn't really make a lot of sense to knock down an existing structure, especially when it has a value to the community, and we're not replacing it. We absolutely have no intention of replacing the house. We're not going to add a 16th unit inside just for the dollars. We really want the appearance of the project to stand out. So that's how we laid out the project based on that. Don't want to change it. So
Thank you. Mr. Twombly, did you have something to add?
Well, I just want to iterate, what Kim said, it just makes no sense for the sake of revising the ordinance of what's said. It comes out onto the, there's two driveways coming out of the project, but there's only one on Cutler's Farm Road, and the other driveway that's a private driveway is a quarter of a mile away from here. It has no relevance whatsoever to our project. And to be truthful, I bought the house in order to comply with the 10 acres. I put $40,000 into it. It's absolutely, I stripped the whole thing. It's absolutely beautiful little house. And we'd be taking it down and losing $5,700 a year in taxes, which I think the town can't afford at this point going forward at all, which, it's the sake of amending the thing. I think it could be done very easily.
Okay, but for the sake of this current application, your intention is to remove that house?
Yeah, we have to say it's being knocked down. That's because we want to get started. It's,
Okay.
just thanks.
Understood. Thank you. Any other questions? Anyone?
No.
Staff? Anyone from the audience? Anyone from the audience? Anyone? Back to you, Mr. Bjorklund.
Thank you very much. Thank you for all your consideration.
What do you think? All right, hearing closed. Next up, item number 11, RAA 2017-04, file number 987E. You're welcome, good night. Community-wide events, mobile food vendors. Commission proposed zoning regulations text amendment to establish permit and land use standards and requirements pertaining to community-wide events and mobile food vendors, food trucks, affecting existing 2.2.1 and 4.1.3, and adding new 6.10 and 6.11. This is reconvened from 5/4/17. And
Got the letter from the chief.
Will,
I believe if I'm correct, the only open item was some,
Well, we had new exhibits.
yeah, well, that's the one item. There's a new there's just one exhibit, isn't there?
Police chief.
The police chief,
Yeah.
I think the fire marshal was old.
Yeah. The one issue that I recall that was open was you had asked us to go back to the police chief and get some explanation as to his commentary. He provided a response to me in an email, which I forwarded on to you, and I believe that was the only issue that was left open.
You all received the letter, copy of the letter from the chief of police? Okay.
And I did have an opportunity to speak with Bill Davin, the fire marshal, with regards to his inspection. He reiterated again that it's important that he does inspect these things. Obviously, they have propane tanks built into them. He certainly understands that that would most likely occur, as I had represented, as part of the permitting process, which is being established with this regulation. And it would be integrated, no different than any other permit process that we currently do, that all those checks go to the fire marshal is in all those checks, at everything that goes through zoning, everything that goes through building already. So it's not really anything new. Obviously, though, there is an importance when you have a vehicle and you have propane sitting as a source of fuel in addition to the tank. I think you'd want your fire marshal to be assured.
Okay. Any other questions or comments from the
Just
commission?
a question on here, regarding this. All right, so we good with Connecticut only?
Excuse me?
Are we good with, Connecticut vendors only? I mean,
That's up to you.
It's
I
justification.
don't have
Okay.
No.
That'll come up in deliberation.
Oh, okay. All right, no, I have no question.
Anything else from anyone? Ready to close it?
Might want to ask if there's anyone in the public that wants to.
Anybody from the public have any comments? Hearing's closed. Next up, site development plans, we have none. Terminations, number 13, extensions, 13-12-SEP, file number 1532A, 10, formerly 2, Victoria Drive, request for 90-day extension. We have a letter requesting an extension to finalize their encroachment permits, traffic signalization approvals from DOT, and the DEP wastewater authorization. They will not be received before July 12th, 2017 deadline, so they're requesting a 90-day extension. Motion?
Move to grant the 90-day extension for
13-12 SCP, file number 1532A. Second.
Now, we have a motion, we have a second. Any discussion? Call the roll. Wait a minute, do we have Jonathan and Kathy seated? Both?
Yeah, they've been
They've been here.
assumed the seating all meeting, but yeah. That's fine.
Formicelli, yes.
Lindstrom, yes?
Ambrosi, yes.
Porter, yes.
yes.
Bond releases and reductions, we have none. Meeting minutes, May 5th, 2017.
I think it's May 4th, that's a typo on the agenda.
Where's the typo, Will?
In the agenda,
Oh.
it's the May 4th one.
May 4th. Okay, present. Porter, Ambrosi, O'Reilly, Lindstrom, and Formicelli. We have a motion?
Move to accept the minutes of the May 4th, 2017 planning and zoning meeting.
Second.
We have a motion, we have a second. Any comments, questions, corrections? Nothing? Call the roll.
Formicelli, yes.
Lindstrom, yes? I guess something.
Porter, yes.
O'Reilly, yes.
Application deliberations and determinations.
answer, I thought you were all done.
REA 2017-06, file number 989E, museums and art studio / gallery principal uses. Porter, Ambrosi, O'Reilly, and Lindstrom. Okay, we have an application to add museums and art studios as defined uses and allowed in our B1, B2, and LOR zones. This application is consistent with the goals and recommendations of the POCD. We defined art studios and galleries, museums. We amended the B1 and B2 districts to allow their use, the LOR district to allow their use, and we established parking standards for the use. Do you have a motion?
Move to approve RAA 2017-06, file 989E.
Second.
We have a motion, we have a second. Any discussion? Okay, just note for the record that this, if approved, this text amendment becomes effective May 31st, 2017. No further, let's see. Yeah, Jonathan, you are not voting on this. All right, call the roll, starting Kathy.
Lindstrom, yes.
Ambrosi, yes.
Porter, yes.
O'Reilly, yes.
Okay, thank you. Moving on, RAA 2017-03, file number 986E, sports field lighting. And we have on this one, Porter, Ambrosi, O'Reilly, and Lindstrom. This application is to allow sports field lighting in industrial zones. It furthers the goals and recommendations of the POCD in regard to economic development in industrial districts. We're adding industrial district sports field lighting as a use, an identified use. We've modified the perimeter areas around the fields so that the school and the industrial district sport fields are the same. Put a 500-foot separation from the industrial district lights and any residential boundary. We've established non-competitive lighting standards. And in the industrial district, we've limited the lighting, so there would be no lighting between 1 a.m. and 7 a.m. Motion?
Move to approve RAA 2017-03, file number 986E, sports field lighting, as drafted.
We have a motion, do we have a second?
Second.
We have a motion, we have a second. Any further discussion? Just note that if this is approved, it shall become effective May 31st, 2017. No further questions, we'll call the roll starting with Kathy.
Lindstrom, yes.
Ambrosi, yes.
Porter, yes.
O'Reilly, yes.
And Dave is absent.
Dave is absent. Next up, 13-12-SEP-A1, file number 1532A, 10 Victoria Drive, Walmart, permit amendment modification.
Excuse me, Chairman. Just a point of order or question. If one of the members is absent, but the other alternate has been here to listen to the tapes, will he be able to?
No, we don't operate that way. If they're not in, they were in deliberations, we already had deliberations the last week.
Okay, no,
Once they're in deliberations,
I'm just
they
asking the
participate.
question because it's worthy of asking.
Okay. On this is Porter, Ambrosi, O'Reilly, and Lindstrom. Okay, there's an application to make some modifications to a previously approved SEP. These proposed changes will not significantly alter the previously approved location, use, and intensity. The proposed action is consistent with the POCD. The changes in the proposed building remains consistent with the applicable I-3 district standard. They've reduced the number of exterior light poles. There's been some modifications to the wastewater treatment plant and subsurface sanitary septic system components, but they're all state Connecticut DEP approved. The bus stop has been moved. Some modifications to the off-street parking areas. And the proposed use remains generally unchanged. Chair will entertain a motion.
Move to approve SCP 1312 -1 file number 1532A 10 Victoria Drive, Walmart commitment modifications as drafted.
We have a motion, we have a second?
Second.
We have a motion, we have a second. Any further discussion?
Yes, I would like to just say that at the last meeting, we heard an awful lot about Brandon. And as we all know, every store that we visit, every Walmart looks different, is different, not only architecturally, but signage-wise. I have no issues with any of the other, moving the dumpster or the ADA spaces or any of that. I think that's all fine, and then it should not be an issue. The signs, I think it's just too dramatic, what the original plan proposed.
Okay. Any other comments or
Nope.
thoughts, anything? Anything else, Kathy? Okay, call the roll, starting with Kathy.
Lindstrom, no.
Ambrosi, yes.
Porter, yes.
O'Reilly, yes.
And Dave Townsend is absent. All right, I would like to go back to RAA 2017-04, the mobile food vendor regulation amendment as submitted by the commission. We have identified and defined community-wide events, mobile food vendors, accessory uses to a brew pub, and we've modified our regulations to allow food trucks at different venues in town based on different sets of criteria. We have different standards for community-wide events or single-day events. We've set up standards for permits for the different events. There was an issue, there was a question raised. The chief of police had some concerns that we asked for clarification on. It turns out that he was thinking about limiting food trucks to Connecticut registered business and vehicles, but he even notes in his letter that this might be considered an interference with commerce, and I think that very well could be an interference with commerce. So I would like to get a motion and get this open for discussion and deliberation.
Motion to what?
To approve.
Deliberate?
To approve.
Oh,
Or motion to,
I'd make a motion to approve. RAA 2017-04, file number 987E, community-wide events / mobile food vendors. The way it was written without adding.
As drafted.
Thank you. It's drafted.
I have no other further
Well, we have a motion, do we have?
Oh, I'll second.
Okay, we have a motion, we have a second. So now we're open for discussion and deliberation.
I know the regulations specify, but I'm just wondering if it's necessary or a good idea to stipulate conditions of approval specifying only one truck at a time, delineating it, and no lights and no sound, and, I know it says it in the regulations, but.
We'd have to change all that. We
Well,
wrote the
we-
regulation.
We already have said no lights,
I
other
know-
than lights on the vehicle itself, no sound systems.
I just want to make sure that,
But as far as, if we're not limiting the number, the site will limit the number. Because they have to, they have to demonstrate that there's sufficient parking, public safety, and all of those issues. If
and that
someone.
would be okay at a park. I have no problem with that at a park, but at the brew pub, do we really want 3 or 4 of them?
If they can illustrate that they have sufficient parking and they meet the standards of the regulation, yes. The site is gonna limit how many can be there.
My concern.
Not only that, but the business is gonna limit how many are gonna be there. Because a guy with a food truck isn't gonna go somewhere if he's gonna sell 4 hot dogs. He might go there for 1 week, but he's not gonna come back. So I don't think that I think it's gonna be a self-regulating condition.
Having not been to brew pubs that have this accessory use, I don't know that from my own experience, one way or another. I'm not disputing you or challenging you, I just plain don't know. If other people have been, then maybe they would know that. I certainly wouldn't. I just don't want it to look like a carnival,
Well, I've been to the one down in Stratford, 2 roads, and they usually have, I think, 3 food trucks out there.
Well, look where they are compared to this. Well, anyway, that's my concern.
Their parking lot is probably smaller than the one over on Main Street.
I'm just not sure this is the direction that we want Monroe to be looking like, but I've said my piece, that's it.
Anyone else?
No.
No?
No questions.
Can you amend your motion to include an effective date of May 31st?
Yes.
So amended. Well, you have to amend it.
Yes, I would amend
The 31st?
May 31st.
May 30th.
Any other items that anyone would like to discuss? No? Call the roll.
Form Kelly, yes.
That's enough.
Rosie, yes.
Porter, yes.
O'Reilly, yes.
Thank you. Are there any other issues that we should be deliberating on? Anything we've forgotten?
Well, you have the other applications that you closed tonight.
Sorry, go about that, right? Can't we do that now?
What did we close? We closed everything.
3 of them.
You closed Mondo, you closed Vet, you closed Burr Corner.
One do with that.
I mean, you can give me direction on those
Yeah,
things.
but that,
Well, let's see, hold on a second, let me get
I think that
my
that's
act
good.
together.
That's done.
oh, it's on.
Yeah, that's not gonna take any time.
Okay, 1615 Monroe Turnpike.
Oh, Mondo.
That's the Mondo zone change.
Not tonight.
There might be a lot of arguing in that.
Well, no, I would like to, we're not gonna go into the final deliberation on it, but I would just like to get a sense for how the commission feels about it. Because the next step is for Will to write either an approval or a denial letter. Now, we're only talking about the zone change. And again, we're not making a final decision tonight. We're talking about which way we think we're gonna go with it. And we will discuss it and deliberate it at our next meeting.
I have a question that I hadn't considered before, that came up tonight, that I just want to make sure I either understood it or it's a non-issue, whichever way it felt. When Mr. Wiley got up and he talked about a lack of access to his property,
Right.
if the ownership of this road is determined to belong to Bruce Mondo, is that,
Mr. Wiley is
I-
guaranteed access to his property on that right of way.
There is a right of way,
He's
or is
got-
it just
Does he
assumed?
have,
that it's a right of way?
does he have a right of way?
It's a right of way. Every road is in a right of way.
Huh?
Every road sits in a right of way.
Okay.
Okay?
regardless
The
of
right
who
of way
owns
is a
it?
strip of land that is between Mr. Mondo's two parcels. It fronts on his two parcels and it fronts on Mr. Wiley's parcel.
We're gonna continue to call it a road, not a driveway
He
Yeah, see,
he
that's-
uses it as a driveway. The town does not maintain it. I have no idea. The state doesn't maintain it. We don't know really what it is as far as the road status. We have an inkling that it was probably
It's
the
gonna
old state
stay as a
road.
road then.
And it probably got abandoned by in the sense that they stopped doing anything with it. It didn't officially get abandoned that we know of, which would have then opened the door for them taking any regards, in all those situations, never loses his rights to pass over the road. If, let's say it was a town road, let's say we knew it was a town road, and the town abandons it officially through an act of the town council, Mr. Wiley still retains that private
Let's say
easement
it's
over that.
Mondo's property.
But
He
who-
still
but who
retains an
maintains
easement
it?
over it.
Based on what?
State law.
But
Just
who's
because
gonna
it's there.
maintain it if it gets full of potholes?
He has I don't know what the right term is,
But it's a
but
state statute.
he has, if it's a public road, he has a public road.
It's
Everyone
private
has a,
property.
if the public road becomes private, he has a private right that survives. He does not lose that.
And they
Whether that
weren't
lets him
denying
subdivide
that.
his property is another story.
So
but
basically, well, nobody's ever gonna quit claim deed the road over to them.
Quit claiming the deed doesn't do anything.
Right. so
That
it's never
doesn't
gonna-
resolve ownership,
right,
that doesn't
Mr.
resolve
Wiley
status.
still has the right
To use that road.
to pass through there to get to his property.
No,
He
what
does.
if he does wanna subdivide it?
Well, then he'll have to prove to you that he meets all the standards for zoning and
But
subdivision.
that, what we're doing now will have no
No,
effect
the
on
zone has
that.
no effect on it.
So,
Thank you.
so, does
It's
it
not wide
matter
enough anyway.
whether or not
Well,
this
you have to improve it.
disputed right-of-way is a driveway that is owned by someone who says, I'm not gonna pave it, I'm not gonna plow it?
It's not a driveway, you should forget about that,
Okay.
okay?
So if it's a road,
Yes,
It's not a road either.
yes, it is a road.
then somebody needs to maintain it, and if Mr. Mondo says, I have other access to it, I don't need to do that,
He's gonna have
what
to-
does that
Those aren't
do?
really your concerns, those are civil concerns,
That
unless
is
the town
not
wants
my
to take
concern.
ownership and say they own it, and then they'll maintain it. But as long as the town doesn't own it and doesn't take maintenance of it, that's not really the town's problem.
Okay, I just wanna make sure what our problem might be or not be, okay.
But isn't the application part of one of the options given was that the road wouldn't be part of the application at all?
That is one option, and that would be my strong recommendation, since we don't have a clear understanding of who owns that property. And our regulations do not allow us to change, we can't have Mr. Mondo
Claim ownership.
applying for a zone change on a piece of property that it's questionable whether or not he owns it.
Well, he's gonna have to go to court and prove
No,
whether or not
no.
he acts something.
You see, he can't change the zone,
Right.
but, if the town goes in to rezone
Mhm.
an area, the town rezones the entire area.
Okay.
Personal property, town property, state property, we just can rezone it. If Mr. Mondo applies for just his parcel to be rezoned, and if the commission is so inclined to approve that, we will have a piece of B2 property, we will have a strip of RF3 land, and we will have a piece of B2 property. And the town
Can just change
can,
that.
in order to create a consistent zoning area, we can change the zone on that road.
It's RF3 behind
I
though.
think
so
that's the best option.
Strip
Go
is leading
forward.
to an RF3.
Yeah, that solves the zoning issue.
So we would be like changing it to B and then RF3 would be behind. the
Correct.
That
access.
remains.
And he would have
Access
access
to the-
over the B2 property to get
So
to
that
his
doesn't
R3
change
property.
anything either.
Doesn't change anything for him in the back.
And that zone, that land in the back, of the residential zone, is that Monroe or Newtown?
It's Monroe.
There is, he
Parts of
lives
it-
in Monroe.
So his address is actually Monroe.
He's behind
No, I know where it is,
1603
like
and
the road,
1615 Monroe Turnpike is his property, and he
Says it as
abuts
well.
the town line.
Okay.
So I just have one concern about doing that. If you leave the residential property in between the two, if, one of the things you do when you rezone a property is you ask the applicant to demonstrate to you that it's buildable and that it's feasible. One of the things that I'm a little concerned about is if it gets approved and it has that residential strip, he can't use the residential strip for access to the
Right,
property
for
as he
commercial
was showing
property.
on his plan. However, they were showing another driveway going out to 34. I'm not sure that they can procure that, because right now, that lot has access on the residential, call it a right-of-way, right? The state isn't obligated to give them access from the state highways, and they don't like to do it either. You're gonna change the zone, and that's gonna put a commercial driveway near an intersection, a major intersection, and I don't know if they're gonna go for that.
Well,
So-
that may be a problem, but the
I know,
existing
you think
driveway,
it's-
hold on, the existing driveway, he also has land that he could turn right very quickly into that property within the business zone without going into the residential zone.
On that,
He also has a strip of land all along.
well, there's,
110.
there'll be frontage on 111 and frontage on 34. It's just that, I don't know how practical that access is. He didn't,
No,
one of my,
I'm saying there's land that he can actually use the existing first few feet in the right of way of
Why?
111 and turn directly into his property.
oh, so, yeah, but it would be 111.
Yeah, off the existing cut on 111 without ever going into the residential zone portion of the property.
So the residential starts a ways into,
Mhm. Well, you'd stay within the state right of way and then, yeah, and you can turn.
It wouldn't be optimal, but
No, it wouldn't
would
be optimal.
possible.
well, anyway, that was my
The fact of the
concern.
matter is, if the commission is so inclined to grant this zone change, I would like the commission to very seriously consider making it a consistent zone area and change the zone on that road.
Well, right, if it doesn't affect the property behind it.
It does not
might
affect
as
the
well
property
do that,
behind
right.
it.
So that would be a separate application.
It would have to be a separate application.
Realistically, it appears it should be a business zone. I mean, you know,
Take it
regardless
away.
of the POCD and all that,
Right.
where it
No,
is. and
no,
how-
in accordance with the POCD, it should be a business
Well, that's what I'm
zone.
saying, you know, I think it should, I don't think we're.
You know,
picking
the funny thing about the POCD is, you can go through there and you can pick things
Nitpick
out
everything, that's right.
to make any argument that you want. The fact of the matter is that our commercial corridors are lining Route 25 and lining Route 111. And our POCD clearly says that we have to establish our commercial corridors.
I think it's appropriate that it be zoned, that's my opinion, that it be zoned B2. I don't have an issue with the fact that we're gonna change the zone.
Maybe like it, because I'll be back here where.
No, it would go with it.
No, I think the plan
The
should
how-
separate the road
The how-to,
and then we'll go and we'll make it the same.
Is everyone in agreement that the road is not part of, not to be considered part of this application?
I'm right.
Yes.
All right, so the commission would like to move forward, looking towards an approval for the lot, not for the right-of-way.
Okay. Okay.
do you have a comment that you'd like to make to us?
Yeah, let's get to the next one, so I can go home.
My comments, well, just to,
Well, we got another hour to go.
my comments to that really would not apply anymore, because they were things that were needed, you know, they can't submit additional information afterwards, so it would just be.
Okay, veterinary clinic. Some of you will remember, I guess just Kathy.
That's me.
This doctor was in here 3 years ago,
2014.
and he was looking to do the same exact thing, but I think where the
Where the
post
post
office
office
is.
is.
And for some reason, it lapsed, and the post office took the space, so now he's just coming in for a new space. I think it's a pretty clear-cut application. I don't know.
And
how-
especially since he claims that he has addressed the issues that were left over from, like
Yeah.
that. I mean, unless Will knows something that we don't know.
No, he's good.
I think it's.
Okay. 269 Purdy Hill Road.
Oh, the house.
They are proposing to take the house down because that is it's not in compliance with the current ARR regulations, having a driveway to go out to Purdy Hill Road. They've agreed that there will be something in there that if Mr. Twombly's not doing the landscaping, they have to submit a new landscaping plan. They're going to come back to staff for approval on the lamp post lighting. They said that there's not going to be any lighting on the property sign. What else?
There are a host of other housekeeping things that they have to do. There, all the HOA and age restriction and the bylaw documents all have to be provided. There is.
Can that be a condition of approval? Or should that?
Well, I guess it has to be now.
Well, yeah, since we closed the hearing.
There's drainage easement also has to be prepared, and there's edits that we had mentioned in our letter, so that could be conditional. There's housekeeping to the zoning data table, that has to be done. Some details to the lighting, to the sign, excuse me. They did represent that they weren't doing millings anymore, correct?
Correct.
Okay. Nothing bad. There's also a condition that would need to be developed about, if you recall, they were looking for some flexibility in single-story units, two-story units, and the materials and the options chose. And we have to keep track of the setbacks, so there was some movement of where they might place the units and the separation standards. And so there should be some condition about, keeping that on track, and so that there's periodically checking with, making sure as they develop the units that they're not boxing themselves out and they're still compliant with coverage and all that, and within the confines of what the drainage report, the extent of coverage of the drainage.
Okay.
So this one's gonna be yeah.
So on mine, I got,
So it may take me longer than, well, we have
3
we have
weeks.
3 weeks, so.
on mine, page 3, items E, 4, 6, 7 would be applicable. Items H, 1, 2 would be applicable. I, 1 and 2 are applicable. My suggestion would be to, per their, they talked about the wetlands approval for the removal. My suggestion would be to make it contingent on procurement of a wetlands approval prior to the issuance of a demo permit. All right?
Okay.
And the items that I had on page 2.
Don't you want that before we do the plan? They have to show the restoration of that area on the plan.
Well, I mean, that's up to the commission. That's gonna,
Because we have to sign the plans with the reclamation.
I mean, we have a pretty good idea that they're going to be looking for some venue to keep the house.
Yeah, that's.
They're agreeing right now to get this approval to knock the house
Take it
down.
down,
But I think that they're going to be looking either for a text amendment change or some other, I don't know if they'll go ZBA. I think they're going to be looking for a way to not take down the house.
Yeah, I mean, ZBA is not really a viable route.
There's really no hardship, I
Yeah.
think. I don't
The-
think.
the
So they have to
the
come back
regs.
to you with a text amendment of some.
Didn't they say they explored everything?
They wanna get it
Try
done
to
though.
do it without doing the text amendment.
I'm sorry, I didn't hear you, Kathy.
I thought they said they had explored every option that there was.
Well, they have explored every option that would give them a quick answer on this application. They want to start.
Yes, they're anxious to get going.
So if they get their approval by agreeing to knock down the house, they're not gonna knock it down until they have 80% of the COs. So that's gonna give them
Trying
several
to figure it out.
months to work on something else.
But the reclamation is really, that should take Dave, about 20 minutes, and
You know, a condition of approval that, you know, they need to provide that prior to getting a demolition permit for the house.
That'll work for wetlands, as long as they approve it before the work happens.
Yeah.
It's-
well, it's just gonna have two sets of plans, that's all.
Yeah, it'll be, well, it would be like on its own, you know?
Alright.
And then, so we'll put that in, and then, I'm assuming, you know, and my role is to point out things, and I did, I pointed out about the layout deficiencies, about backing out. Yeah, that's somewhat inherent in this kind of project, so those go, I'm assuming. And then just asking you about, did you have any ideas or thoughts about any sidewalks anywhere?
I don't think they're necessary.
I'm inclined to, let them go without them.
It's a relatively small development.
Yeah,
It's not
it's
gonna be a
pretty
lot of
small.
traffic. People aren't gonna be in the way of cars.
Less
They don't have it in
impervious
Northbrook,
area.
they don't have
Yeah, they
it,
don't have it in Northbrook where there's
or
plenty.
High Meadows,
Yeah.
which is,
Okay, so that one goes, and I think that covers all mine.
No sidewalk?
Anything else? on
Oh,
that?
one last thing, my bond recommendation was the 85,000. So,
Yeah. I think that they were in agreement with that.
Yep, they were.
Anything else that we should be deliberating on? Nope. Okay. Regulation review amendment work session. Let's talk tomorrow about what next week's schedule looks like. I don't have my schedule in front of me.
Okay.
Chairman's report, don't forget, we changed the date of our June meetings, the 8th and the 22nd. Okay?
Somebody else sent an email to remind us, huh?
Right. Anything else?
Write that on my calendar.
Motion to adjourn?
So moved.